Whereas it is supposed to come down by 5
Restoration means you have got a chance. No, not now. Yes.
40% constructing illegal contractor.
Handover. Yes. Carrier.
Regarding a tender, my lord,
They have been awarded what contract? Handover. Yes.
26, this matter was previous Monday, it was mentioned. 27, the requisition has been sent from a lordship's office, court, my lord. On 30th also I mentioned this, my lord. I am praying for extension of interim order. Tender matter, my lord, I was enjoying interim order, my lord.
এটা আলাদা করে রাখো তো, এটা কেন আসছে না? যেটা ডেকে পাঠিয়ে জিজ্ঞেস করো। Yes.
My lord, that lordship will kindly include this as a supplementary list and, my lord, excess.
Yes, whenever the file comes, extension of interim order matters have to get precedence. Yes.
Mother, before your lordship, just 60.
Please be a bit louder.
My lord, mother, before your lordship is a 65 years old lady who driven out from his house. Initially gifted the property to son. Thereafter the SDO cancelled the deed. He challenged that has been dismissed by the DM. Now, son, before your lordship, mother is out of home, my lord.
Wait for some time. Yes.
Lordship, I mentioned this matter earlier on.
What is your urgency?
Lordship, the respondent has started construction.
Use the mic. You have the microphone before you.
Lordship, the respondent has started construction on the irrigation land, Lordship, and has searched the egress and ingress of the petitioners.
Wait for some time. Sorry. Yes.
Lordship,
Siddhartha Mitra, senior advocate, on Friday mentioned this extremely urgent matter. The pleasure of your lordship is to file application and to mention it on Monday. My lord, we have filed the application, served it, and my lord,
Application you have given
yes,
given the number?
Yes,
Yes,
number. I'm grateful.
Well,
Yes.
well, I want 5 more minutes in the matter that your lordship concluded hearing on, my lord, Friday. My lord, there are some documents which we have drawn your lordship's attention to. Just 5 more minutes, my lord, by the clock.
It is
Whenever
not
it-
appearing as for
No,
judgment.
my lord, it is not appearing for judgment. My lord, your lordship had reserved orders.
Very well. That's an appellate side matter.
Yes, my lord. Appellate said to.
Yes.
Yes.
I was for the.
Yes, you were there.
Yes, my lord, I'm mentioning notice. My lord, another matter I had mentioned on Friday. I'm sorry.
Very well. This will appear as to be mentioned. যে কোনো দিন যেদিন আসবে ফাইলটা থাক আছে বোধহয় আমাদের কাছে। একটু মেনশন দিয়ে দাও কালকে। Yes.
My lord, one more matter, my lord. I had mentioned this on Friday. Your lordship was, my lord, this is where, my lord, the government had said they will vest the land and, my lord, take forcible possession. So, my lord, I filed a writ. My lord, there is a.
Mr. Shah, no further inclusion for the timing.
My lord, I have also, my lord, a urgent matter, my lord, the tender, yes, on 30th, I received the notice, the financial bid is to be opened tomorrow. A technically unqualified person has been made eligible. I'm challenging that, my lord. My lord,
So, Koji,
tomorrow
these
the
tender
financial
matters
bid
have to wait for some time. They have to take a backseat. All the tender matters are coming up and these ordinary people are suffering.
My lord, my urgency is, my lord, that on 30th, I received the notice.
Yes, I appreciate.
But this is
Hand
the
over the
thing
slip we'll consider.
My lord, this is my,
No. You have to file in due course.
My lord, I'll
Or
file
tomorrow it will be open.
tomorrow. is
Where
going
leave
to
is granted. It will appear but tomorrow.
Yes,
10:30. Yes.
My lord,
Open
may
to
I be
the other way.
permitted to mention on urgent matter, this matter was heard by the lordship on 19th May. The lordship passed an order to maintain its status quo. But on that day, the station manager disconnected the service connection. The matter is under heading adjourned motion, my lord, 201. The petitioner is senior citizen, everybody is suffering due to extreme hot.
Hand over the slip, এটা upgradation যেটা আমি বলে দেবো।
Upon mentioning, my lord,
এগুলো upgraded matter দিয়ে দেবে যেগুলো দিচ্ছি। Yes.
upon mentioning, my lord, matter considering urgency matter was listed, but it was not on the heading upon mentioning, but it was not gradually it was number is.
It will go down gradually. Yes. All the matters that is happening. No. Yes.
Hearing matter 2018.
No.
Sir, may I seek my lordship, I can 95. The urgency is that I have to travel on 24th of July. My passport is seized. In spite of the fact that there was a deduction of Reserve Bank to seize my passport, thereafter the deduction was withdrawn. Then also, my lord, the passport is not being.
Hand over under the upgraded matter heading, but it may go down gradually, as in the other matter.
I am.
It will appear under the upgraded heading. Yes. Yes, ma'am. What do you have to say? Please mention. Yes. অরিত্রটি বসো তুমি বা সরে এসো।
Petitioner is the manufacturer of the e-vehicles and he has applied for
Manufacturer of
e-vehicles, electronic and battery based.
e-vehicles. Yes.
Yes. Yes,
What is the urgency?
urgency is that he has applied for the certificate of registration, but the concerned department, that is the respondent, is not.
No, ma'am, you have to wait for some time. I'm sorry. Yes.
Business of the matter the suite. Well, he saw has been attached by the order of the.
Hey, what is this?
Matter the violation of the provision of the West Bengal. Here it was given. Matter the year the subsequently attached.
Sweets have to wait for some time. Yes.
There are some deeds that were executed after that for commission of deed of state, but the deeds were not delivered and because of that, they're suffering.
Not now.
The wet bill has been passed in April 2022. Thereafter,
Wait for some time. Yes. Yes.
Getting through issuance of firearm license for second time.
What license?
Firearm.
Wait for some time. No. Firearms can wait. No. If sweets can wait, firearms can also wait. No. Hand over. Not Mr. Nila. Yes, you have to mention something? No.
Your Lordship,
Wait for some time. Wait for some time. No, wait for some time. Yes. Sorry, no. Not at all. Yes. That cannot be an. That is the least urgency. So if I refused once, I'll refuse again. That furnishes me ground next. Let the government suffer for the time being. Yes. Pardon?
The post of MMR is filled up, my lord.
MMR, wait for some time.
My lord,
No.
my lord, this matter, my lord, what happened, my lord, because of the pendency of this writ petition, the writ petition is not taking any steps, my lord. I am not allowed to operate my bank account, and I have a order from the government of West Bengal of 77 lakh. They mentioned they did the matter before the regular bench, before vacation, and they took the matter to the vacation bench. Thereafter, they again came to your.
What are you?
I am the respondent number 5. I am the partnership firm's partner. The similar matter.
You are responding to the writ petition.
Yes, I am the similar matter. The same issue, my lord, was already decided by your lordship, my lord. Only the bank was different, my lord. I am without this.
Wait for some time.
My lord, kindly, my lord.
Wait for some time. Yes.
Lots of petitioner battling between life and death. Lots of the case medical negligence due to wrong medical treatment on kidney.
What is the ailment? What is the illness?
Illness due to wrong medical treatment, which kidney become damaged.
Age
75 years.
hand over. Yes.
Contempt application, Lordship, for inclusion in the list, Lordship, on 13th January.
Contempt can wait for some time. Contempt not.
2020.
My lord, the petitioner's child's name has been changed, address has been changed at the instance of the petitioner's husband. The child has 2 birth certificates, 2 names and 2 addresses.
Hand over.
I'm grateful to your lordship.
Pressure of your lordship's courts, my lord. Even after 3 times, my lord, mentioning it is not entertained. And therefore, my lord, I am mentioning before your lord.
To be mentioned for release.
Release the matter.
To be mentioned for release. Your lord, bracketed to be mentioned for release, bracketed on prayer of petitioner. Yes.
Your lordship, the petitioner's insurance claim has not been settled, and there has been various violations of the Insurance Act and the rules framed thereunder. My lord, there is a scam that is going on, and
motor vehicle is what insurance?
My lord, it is a motor vehicle insurance, and now the urgency is that the motor vehicle has been dismantled at the instance of the insurer, and the garage is asking for rent for the property that is.
Yes.
My lord, may we permit to mention 2 items, one contempt application, another new motion.
Contempt, no. What about the new motion?
This matter was filed in the month of February, but till date.
No, sorry. Yes, next. You already had your turn. Hand over. Yes. No, before you, the lady is there. Urgency. Not now. Yes. No, I'm sorry, ma'am. Yes, what is urgency? They will hand over. It's regarding pension. Regarding pension. Even then, hand over a slip. Hand over slip writing item 235. It will appear in the upgraded list. Yes, next. Not now. No, for the tender for the time being. No. Yes. Urgency. Wait for some time for construction. For permit. Yes. Hand over. Please be a bit louder. Where? So what has been done? Go there. Who's paying you? Hand over the slip. Yes. Anything else? All are most are senior citizens, not them, their clients. I'm extremely sorry, but wait for some time. Yes.
This is an extremely urgent matter. The Principal Secretary, the authority from WBMC has read an unreasoned order. Uphold the order of WBMC suspending the practice of my client for a period of 6 months. Within 3 days, the writ has been filed.
Hello. Yes. Whenever it comes, the file comes.
Former public prosecutor. After the death of her husband, she hasn't received the outstanding.
Hand over.
Lordship, may I mention two matters, Lordship. One for inclusion in the list. The Lordship Bank Authority has frozen my account, Lordship, without any notice.
What about the other?
Other is Lordship upgradation of matter. Item number 1.
Not the upgradation, the other one, yes.
Inclusion. File against the bank for taking surface action.
Can't hear you. Surface action has been taken.
Yes.
You didn't repay the loan, it has been taken. No.
Withdrawal.
Withdrawal. Welcome, most welcome. Yes.
Lordship, I am also praying for release of this matter.
Hand over. Release it, petition has
Your Lordship, in this matter, the respondent had a liberty to file the affidavit in opposition until July 30th, but they didn't file any opposition, and the petitioner didn't receive any.
So what is the urgency in the matter?
Urgency is that the petitioner is paying the EMI with the interest.
I'm sorry, we have to wait for some time. No, not right now.
Please, my kind.
No. Yes.
Lordship, the respondent bank is not returning the original sale deed to the petitioner.
Had your quota today, ma'am.
Item number 230. This is election matter, my lord. Your lordship took the matter on 27th. Since none appeared on behalf of the State Election Commission, your lordship posted the matter on 30th. But from 30th, the matter has gone down. Now, my lord, item number 11 is identical.
You see the reason of going down also?
No, my lord, the item number 11 is same matter, my lord. Election matter, my lord. Fifth, the duty has been given. My lord, I'm beseeching, my lord, kindly take this matter along with item number 11, my lord.
What's the election? We are overfed up with election. Yes.
My lord, there is a new motion, my lord. The urgency, the petitioner is a poor fisherman. His boat license certificate has been cancelled.
Boat license has been cancelled.
Boat license.
Hand over. Yes.
Yes. I have applied for right to information, no answer, because I was a BLR at that point.
So, no, this is not an urgent matter.
No, there is a allegation. So many land I have been transferred as a Borga and Malord West Lake interest. No such Malord order and communication with which DAG has already been transferred.
No, Mr. Munda, I'm sorry. Right to information. No, I'm sorry.
I have been
No, Mr. Munda.
I am
No.
suffering suspension.
No, even then. Right to information is not so.
Totally fake allegation against.
No, Mr. Mundul. Sorry, not right now. Yes.
May I have the lordship stand if to mention matters for matter for non-prosecution?
Non-prosecution handover, yes.
They have a lot to mention. Item number 75 of my lord. The urgency is that, my lord, the petitioner has challenged the unilateral change of the tender document, my lord. And instead that the respondent authority is still giving the purchase order in favor of the petitioner, which petitioner is not being able to fulfill. Now they have initiated the banning proceeding, my lord. It will become infraction.
No, not now. No.
Yes, in the case of non-payment of gratuity, actually ALC passed an order in favor of the petitioner. He has retired 4 years before.
Hand over.
two motion, my lord. One of the petitioner is more than 85 years old, and from last 30 years, the housing board didn't get registered the car parking in favor of the petitioner.
What about the other?
Other is same matter, my lord. One other one is 75 years old.
Wait for some time. I'm sorry. You could wait for 30 years. Wait for some time. Yes.
My life consignment of life retained at the
Very poor? Poor gunman. Wait for some time. You will become rich after the elections. Yes. No, no, no. There is no use listing any further matter because the list is already too full. Please wait for some time. I'm sorry, but wait for some time. Yes, Mr. Chatterjee. Chatterjee, not possible now. Yes. No, I'm sorry. I'm sorry. No.
For inclusion of the list, respondent bank is not providing my proposal letter of the loan account of the petitioner, my lord, and request is
What are you, the company?
no, my lord, individual.
Hand over. Yes.
My lord, I
Yes, you.
my lord, I seek upgradation of two electricity matters, my lord, since 2022 due to
Impossible. Electricity matters now. I'm sorry. Yes. The lady behind you. Mention anyone. Choose yours.
Then the petitioner is working in the cooperative bank, Your Lordship. Now the petitioner are being deployed in the panchayati election. They are not fit for the elections at the moment, Your Lordship, for the duty.
Election matter? No, 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 no further. Yes.
The matter pertains.
Yes, you.
The matter pertains to SABYASACHI application, Lordship. Lordship, the petitioner is the corporate guarantor. But
Section 14 has been passed.
yes, Lordship, no, it's not section 14. 13.4. It is now in state of 13.4.
My lord, this is a motion matter. The petitioner took a go down in rent and suffering from irreparable loss and gave the vacant land to the respondent. As the respondent is not paying the money, the petitioner is facing from such financial loss.
That is reportable. Next.
Your Lordship, I pray for upgradation of the matter as the petitioner is engaged with the business of casting ferroalloys and he has been stopped for last 1.5 years. The pleadings are already
Hand over.
For extension of interim order, I
Yes, please.
mentioned on Monday, my lord, Lordship, directly to appear, but it's not appearing, my lord. Interim order was till 30th of June, my lord.
No, the interim order extension will first. First priority the extension will. Yes, yes, Mr.
We will be allowed to mention 3 matters for upgradation. Our
Choose your one.
Lordship,
Which is the worst matter?
Section 14 application is pending since 2022.
Wait for some time. Yes.
The new motion, my lord, during subsistence of the agreement for 3 years.
You don't have your expression is not important. What you say is important.
Hot water has been cancelled. Even my capital has been blocked, amounting to more than 3.5 crores.
Please wait for some time. Please wait for some time. Yes.
3 years old.
Since you're senior, I'm rejecting. Right message should go. Too senior to mention now.
difficult times, my lord, for this.
Yes, Mr. What is?
Before, my lord, twice lordship said to come afterward. 24 months, my lord, the state administrative tribunal is not there. My lord, from 2019, my promotion and my
Hand over, please hand over. Yes. No. Next.
This application before the environment already. We have filed
Yes.
The project has stopped since January.
I'm sorry, you have to wait for some time. Yes. Some more time. Wait for some time. Yes. Wait for some time. Wait for some time. Yes. Please be a bit louder. What is your urgency? That is not an art. Wait for some time. Yes. This is the last time I'm going through. And don't rush. Yes, you first. I saw you nod your head. I said no to him, to you also. Yes. Section 14, no.
My lord, I applied for passport in 19, I got it in 19, and I saw the letter, the date of my birth was wrong. So I informed them and I sent it back. And since the COVID came and still there's no response, they are saying over phone that you cannot go to Bangladesh. You are a Banerjee, what you should meet someone there. My lord, I'm 65 years old, my lord. I'm a candidate, so why should I go there? Do something to sacrifice money. What kind of
What should I do? Should I take it? After Sandil Gochu? On that ground, refused. Whatever you go through, that is not important.
I'm 65, and passport of the society, we cannot do anything. But
They will hand over. Not now. Yes.
Yeah, I will also.
Expression is not important. What you say is important.
Very important, my lord. They say is pending, my lord. I am the landowner. Section 14 order has been obtained by the bank, my lord.
Wait for some time. No.
Appreciate, my lord. Any day, my lord, I'll be disposing of all the senior citizens. For the time being, my lord, I need an
All are senior citizens, but I'll check up. At a SC লিখে রাখো তো এখানে SC মানে senior citizen.
landowners, my lord. My client.
If all are not senior citizen, I'll remember this. I'll taking a note of it. Yes.
Motion law, filed in 2020, not even.
You have sufficient matters in other.
The petitioner already paid the entire dues to the bank.
No.
But bank not releasing the charging dues.
Not now. Yes. Next.
Motion law.
Won't help you. Yes.
Intends to withdraw the.
Petitioner?
Intends to withdraw the.
Withdraw the and hand over. Yes.
E-auction,
No further mentioning this site. Sorry. Next day. Next Monday. Yes.
2022, the process of e-auction conducted by the respondent bank during the pendency of this instant writ petition, presently some unauthorized person demolishing the existing structure of the mortgage property and trying to alienate and change the net.
And what is it? Yes.
My lord, may I be permitted to mention this is a very short matter, my lord. The facts are admitted, my lord. We have incorrectly deposited money in a different bank.
Shortness is no more a factor.
My lord, this is a 2021 motion, my lord. We have tried alak before Justice Mantha, my lord. Then Justice BHATTACHARYA, my lord. We are trying alak, my lord. May fix it.
I don't want you to wait before another justice, but they did not come in the list for the time being. Yes.
May I
Yes.
permit one mentioning lordship, the new connection lordship, the quotation was a deposit lordship, the kindly domestic connection lordship, connection is a.
Wait for some time. No.
Urgent.
Not.
Here the question is that is related to railway. A matter of 2019 and the petitioner and the appellant, they're not getting the materials. Railway is not delivering, although they own the bid successfully.
Hand over.
They are not.
Yes.
Earlier occasion, my lord, earlier Monday, my lord, I mentioned the matter, two matter, my lord, your lordship, new motion matter, allow, my lord, didn't appear, my lord, may I?
Yes. Yes. Yes.
চেষ্টা করা যায়।
Hand over. Yes. Wait for some time. Yes. Yes.
Already 20 days. There are advertising in the paper. Program taken.
Hand over. Hand over. Yes. Hand over. Hand over. Very good. Call on the list. No further mentioning. No, you were not. All of you came in after. After the mentioning started. I've seen all of you. All of you came in much after the mentioning started. I said you were not there when the mentioning started. You are definitely not there. Please don't say that in my court.
No, my lord.
I take full care of accommodating all who are there at the time of when I sit in court. You were not there. None of you were there. The first 3 rows were there. After that, no. I'm sorry. Call on the list.
My lord, may I have the liberty of mentioning one matter, my lord? I was in virtual since morning, my lord. May I have the my lord, pleasure of mentioning?
Yes. Yes. Yes,
My lord,
please.
this is a writ petition, my lord, where the pleadings are complete, my lord. It deals, my lord, with the illegal appointment of a person not qualified to be in the Waqf board, my lord. My lord, the pleadings are complete, my lord. Any time, my lord, in the second or third week of, my lord, July. For
Hearing matter, it's very difficult to take up now. I'm extremely sorry.
Lord,
I
I will
evidence.
give my written notes of submission, my lord, and not argue for more than 10 minutes, my lord.
Please wait for some time at least. Immediately I cannot accommodate. I'm
No,
extremely
at least, with great respect, my lord. Can it not be included in the list, my lord? At least
matters also. No, I'm sorry. No,
if
sir.
it could be just included in the second or third week of July, my lord. That is my humble request.
Not right now. Not right now. Yes. No.
My lord, adjourn motion will be taken up.
Call on the list.
For judgment, item number 1. I beg to appear for the petitioner, my lord.
Item number 1.
I beg to appear for the petitioner.
In view of the above observations, WPA 9191 of 2022 with IA CAN 1 of 2023 are allowed on contest, restraining the respondent authorities from preventing the petitioner from traveling abroad. Alleged LOC issued by the petitioner cannot be further acted upon, having spent its force and being divorced the law. Even apart from the same, the said LOC is hereby set aside, being contrary to the government guidelines. Respondents are directed to ensure that any communication, if made by the said respondents to any authority for restraining the petitioner from traveling abroad or leaving the country in any manner, shall be reversed, and the gist of this order shall be communicated by the respondents to all such authorities to ensure that the petitioner is not prevented from traveling abroad in any manner whatsoever. No orders to cause, urgent certificate.
Grateful, lordship.
I'm
grateful.
For judgment, item 2 to 8.
I'm sorry, the writ petitions are dismissed.
My lord, only thing there was a stay order for stay of the disconnection notice. But today they will disconnect. Kindly extend the time for making the payment. 7 days. But because one of the disconnection would be given effect to 7 days time to make the payments.
When the above judgment is delivered, learned counsel for the petitioners, you're in all the matters.
Yes, but I'm praying this for the first item number. To item number 2 for the payments. Others have.
What is the number? WPA number. Learned counsel appearing for the petitioner in
13131. My lord, the first
13133 in WPA number such and such. Praise for a week's time to put in the deposits in question, since otherwise the petitioner's electricity connection may be disconnected. Full stop. Next para. Considering the nature of the case, the time for filing, time for depositing the necessary amount, which was disputed in the writ petition by the petitioners, is extended till July 10, 2023. Full stop. Let this order be treated to be a part of the above judgment. WPA number, which one?
1333.
13133.
Yes.
Of 2020.
My lord, subject to my lord's kind consideration. If my lord considers, my lord,
Yes.
my lord, since I have instructions, my lord, they are overdrawing. So can it be 5 days, my lord? Because there's security deposit, my lord, the licensing, my lord. Because overdrawing and
5 days and 2 days grace.
Grateful.
Yes. Next. Rako.
Extension of interim order.
File.
Lord,
Item 9.
Time.
my lord, I appear with Mr. Chakravarti, my lord.
Yes.
Lordship,
But
my lord,
you are for the respondent.
Yes. Being satisfied with the prima facie case made out by my client, my lord, your lordship was pleased to pass an interim order on 20th June.
When did it expire?
My lord, it expired on 30th.
This is an application for extension.
Extension application is there. Yes. Now, my lord, your lordship indicated the matter was mentioned by my junior on Friday. Now, your lordship indicated that the matter could be disposed of also.
I indicated. My lord, may I? My lord, his challenge is on two folds. First, that my taking over possession is on the basis of a surface action, which probably in 2019. And he says he is owner of that particular flat since 2014. So there is a dispute with regard to title. And I have initiated a surface action, be that as it may, whether right or wrong. My lord, my humble submission is he has twofold reliefs. Either to challenge my surface application, surface action before DRT, or my title, or vis-a-vis his title before a competent civil court. If your lordship so pleases,
you are the purchaser.
I am the bank.
Bank. Yes.
Subsequent bank who has enforced the surface action. If your lordship so pleases, your lordship can direct him to approach a competent court of his choice and extends this to some certain
What
period
was the
of time.
nature of the interim order pass?
That I should not take further action.
My lord, may I indicate?
That is fair enough.
My lord, may I indicate? Lordship kindly, because of course I have a remedy under SABYASACHI Act section 70. Now I have been able to make out, my lord, there is a clear infringement of my legal right. I am neither a borrower nor a guarantor,
Yes, I
nor, my lord, a mortgager.
Then also you are entitled to go to before the tribunal.
No, I
That's
have,
the difficulty.
but I tell you, lordship, your lordship has the right, my lord, the power to pass. Or, my lord, I tell you, lordship,
Definitely I
my
have.
lordship, this is not, may I?
Self-imposed restriction.
No, no.
Several judgments are there. All say the same
Yes,
thing. Basically.
my lord, lordship, kindly, my lord, appreciate one thing. 2014, I purchased the property. Now, the same promoter sells the property to someone else, and bank without, my lord, causing due diligence.
I'll give you liberty to approach you.
No,
sir.
my lord.
This is not a fact-finding
My
forum.
lord,
We cannot go into the facts.
on the face of it, I can show that kindly come to this, page. I mean, this is fraud, systematic fraud. Kindly come to page.
Systematic fraud, I cannot go into
No,
that.
my lord, I
In
tell you,
written.
lordship.
I'll give you the
No, no,
liberty to go.
lord, my lord, kindly appreciate. Here is a case, my lord. I purchased the property in 2014. Now, 2019, somebody mortgages the property on the strength of some document and obtains a loan. And
all these pertain to fact. I have to go into the
my
documents.
lord,
at
on
least
the
fact-
face of it, I
on the
can
face of what? Tell me.
my lord, you have to kindly see page 13, 17. How, my lord, page 17, this is my property deed. Then
That is the face of a document.
yes, my lord.
That is only the
No,
face of the document. I also have to
take-
look to the nose, the
I'll
ear,
I'll take
the rest of the body.
No, I'll take your lordship. Kindly
I'll have
take.
to appreciate facts, sir. He's
No,
correct on that.
No, no.
And
I'll
once he has given an easy way out to the court,
No, 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 my
definitely the court will accept.
Lord,
He
lordship,
knows
kindly-
the
my lord,
tactics.
my legal right has been infringed.
No,
So I
not
have-
that.
Now,
But I cannot go into the questions
no,
of
no, no.
fact.
I tell you, lordship, on the kindly come to page 17.
Unless this document comes as a proof on record,
No,
they don't have a
there is
right
no
to.
dispute.
Don't have any opportunity to dispute now.
No.
How can they unless
Now,
it is proved?
Then this is the registered document. I have got it mutated. The electricity bill is in my name. Kindly come to mutation certificate 34 to 39. Electricity bill, everything is in my name. And 2019, somebody takes a loan and bank does not, cause the due diligence, search, and kindly come to the same document in the same manner. He registered, the promoter registers at page, lordship, kindly see page 43. Same language, same ditto. Then, my lord, section 14 order was passed in 21. No notice under section 13 to 13.4 was affixed. My lord, which is the requirement. So I am the rightful owner. Now my right has been infringed on the face. Let them show let them file affidavit. Let them show what steps they took to, my lord, to
Do you have
cause
a
due
defense, valid
diligence.
defense against this? If you
Nothing.
don't have a defense, then I'll direct you.
I would just, without calling for affidavits, I would just like to show two documents, two photographs.
Give copies to him also.
Yes, I will. My lord, this is
Photograph?
Yes, my lord, just.
I'm not interested.
My lord, just one thing. My lord, nothing. I would not show anything apart from
See the
this.
photographs.
My lord, these photographs.
What do you want to show?
Yes, my lord, I had affixed the notices on the same apartment, on the door of the same apartment. After I affixed, my lord, they changed the entire structure of the apartment. The same door is apparent from the nail above this same door. My lord, I had affixed, I had gone through every process, but they have completely changed the nature of this.
একটা order record কর।
My lord, kindly protect my lord, kindly see.
Learned counsel for the petitioner contends that the respondent bank has patently contravened law and natural justice in seeking to dispossess the petitioners, since the petitioners were in possession of the property since the year 2014, whereas the alleged debt, in respect of which the mortgage in question was created, was only of the year 2019. Next para, it is submitted that even on the face of the records, it is palpable that the petitioners are in possession of the property in dispute, in the capacity of owners thereof. Next para, For such purpose, learned counsel seeks to place reliance on the several documents annexed to the present writ petition. It is further submitted that the bank, without following due modalities in law, are seeking to dispossess the petitioners. Next para, learned counsel appearing for the bank refutes such contentions and submits that the bank took all due steps in accordance with law and, as such, the remedy of the petitioners lies before the concerned tribunal and or any other competent civil court. Next para, heard learned counsel for the parties on the prayer of extension of interim order. It is seen from the records that although the petitioners have made out a prima facie case to go for trial, the trial which is required to decide the issues raised are only dependent on a scrutiny of several documents, which are to be formally proved before a tribunal stroke court by the petitioners before being relied upon. Moreover, unless the said documents come on record in accordance with law, which is beyond the scope of a writ petition, the respondents would not have any meaningful scope of refuting the same on merits. That apart, the question as to whether the respondent bank has complied with all formalities regarding the compliance of statute before reaching the stage of section 14 of the SABYASACHI Act 2002 is entirely required to be gone into on facts by the appropriate tribunal. It would be premature and dehors the jurisdiction of the writ court, at this juncture to prejudge such issue merely on the basis of affidavits, since disputed questions of facts are involved. Next para, accordingly, WPA 12042 of 2023 is disposed of by granting liberty to the petitioners to approach the concerned tribunal with the disputes as raised in the present writ petition. If so approached, the tribunal shall decide the same in accordance with law, upon giving adequate opportunity of hearing to all concerned as expeditiously as possible. Next para, however, for the present, in order to grant an interim ad hoc protection to the petitioners till the petitioners get an opportunity to move any ad interim petition in connection with the challenge, if any, preferred by the petitioners before the tribunal, the interim order dated June 20, 2023 is extended, thereby restraining the respondent authorities from taking any action on the basis of the order dated August 4, 2021, passed by the district magistrate, South 24 Parganas, and or dispossessing the petitioners in any manner whatsoever till July 31, 2023, or until further orders passed by the tribunal, if approached. Next para, it is, however, made clear that the ad interim order passed herein is only on a preliminary and tentative basis and shall not prejudice the rights and contentions of the parties before the tribunal, if approached by the petitioners. If so approached, the tribunal shall, while deciding the main application as well as all interlocutory matters, proceed without being unduly influenced in any manner whatsoever by any of the observations made herein, and shall record its independent findings on law and fact. The parties as well as the tribunal below, as well as all concerned, shall act on the server copy of this order without insisting upon prior production of certified copy. No address to cause certain certified copies.
Deeply obliged.
Thank
My lord, I have
according can 1 of 2023 is also disposed of according.
My lord, may I seek a indulgence? Lordship has given time till 31st because these tribunals are not functioning regularly. Kindly give some more time, my lord. Otherwise, because we are also experiencing the difficulty.
Both
we are
the
on-
presiding
We are
officers
on
have
third,
joined.
3rd July.
Both the presiding officers have joined.
But
3rd July. 3rd July, that is sufficient time.
at least till
3rd and 31st.
at least till 15th August, because filing it and it will be listed, my lord.
Make
according
a
to the-
copy paste, make the appropriate changes, file it day after tomorrow. You are capable of that. Your instrumentalities are there. Yes.
Briefly
Next.
obliged.
Thank you.
Extension of interim order, item
Yes.
10.
Please, the Lordship, I am for the petition.
What is the interim order you are enjoying?
Not to install the transformer.
Fine.
My lord, the order is, my lord, can you see?
Yes, I am seeing the order. Yes, Dr. Shah.
In pursuance to your lordship's directions,
Yes.
we have made an inspections. This
What is the result?
report. We have sub copy to you.
What is the outcome?
In
short, yes.
In short, your lordship will find that there is a specific directions that the petitioner will show the alternative locations where the transformer can be installed, lordship. The petitioner has shown the 2 locations. One near the temple, if your lordship kindly see, another in a place where the senior citizen in a park sit, and it has to be dismantled, and we have to take
Park
permission.
has to be dismantled.
Seat, that the seat where it has to be dismantled, lordship. Now, your lordship will find that there is certain difficulties which we are facing. That has been reflected in the report itself, your lordship will find. But there is a full safety measure where it has been installed. There will be no danger. And most importantly, your lordship will find that petitioner is not at present residing at that place. And even in that building,
Transformer has already been installed, no?
Installed, but no connection has been given. Your lordship knows that due to the scorching heat, there is a huge number of complaints, and we are facing huge difficulty on that phase. Even the building where the inhabitants are there, they haven't also raised any objections, lordship.
Yes, what do you say to this?
My lord, we have shown them in the inspection. I was present. First, 5 places has been shown. The picture with me. My lord, I'll file exception of this report within 7 days. My lord, 5 places.
Learned counsel for the petitioner praised for extension of the interim order granted earlier. Full stop. Learned counsel for the CSC Limited files a report, comma, which indicates that, comma, on an inspection held in the presence of the petitioner, comma, the CSC authorities came to the conclusion that it was not feasible to accommodate, to install the transformer in question in some alternative location at the locality, comma, due to the reasons as indicated in the report. Full stop. It is stated in the report, comma, inter alia, comma, that one of the alternative locations shown by the petitioner is crowded by devotees of the temple situated on such location. Full stop. The other is a public sitting space where residents, comma, including senior citizens of the locality, comma, gather and spend their leisure time. Full stop. Even for installing the transformer at the second space, comma, a demolition of the structures would be necessary. Full stop. Hence, comma, it is submitted that it is not feasible to install the transformer in such alternative places. Full stop. Next para, learned counsel for the petitioner refutes the contents of the report and seeks to file an exception to the same. Full stop. However, comma, the fact-finding inquiry which has to be gone into by this court for deciding the issue on facts, comma, regarding availability of alternate space to install the transformer is beyond the scope of the writ court. Full stop. Hence, WPA 13260 of 2023 is disposed of by granting liberty to the petitioner to approach the concerned district magistrate or metropolitan. This is metropolitan or district?
Howrah district magistrate.
Concerned district magistrate having jurisdiction, territorial jurisdiction over the matter with the dispute as raised in the present writ petition regarding the installation of transformer. Full stop. Such approach shall be made by the petitioner in due process of law within a week from date. Full stop. upon being so approached, comma, the district magistrate concerned shall decide the issue in accordance with law upon giving opportunity of hearing to all concerned as expeditiously as possible, comma, preferably within 4 weeks from the date of such application being made to the district magistrate. Full stop. It is made clear, comma, however, comma, that nothing contained in the writ petition and or the report filed today shall be deemed to be admitted by the writ petitioner and or writ petitioner, by the respondents and or the writ petitioner respectively, and it will be open to both parties to reopen all issues before the concerned district magistrate. First up, the magistrate shall decide the issue independently without being influenced in any manner by any of the observations made herein and or any of the pleadings made before this writ court. First stop, till the dispute is resolved by the district magistrate, comma, the disputed transformer shall not be electrified by the CSC Limited. Full stop. However, comma, this order shall be subject to orders passed by the district magistrate at the final hearing of the matter. First.
Your lordship was pleased to grant the time for 4 weeks.
Weeks from date of application, they have to apply within 1 week.
As your lordship.
Because the other persons are also.
And the other, if they fail to apply in default, your lordship kindly make that order also.
একটা order, একটা line add করে নিন মাধব বাবু, in default of the petitioner filing the application within a week, comma, this order shall, the writ petition shall be treated to be disposed of without any extension of the interim order passed there.
Deeply of lordship.
Item 11, top item.
Lordship, I beg to appear on the petitioner, Lordship.
I'm appearing for the
Lordship.
state.
You're for the respondent.
State.
State, right.
Lordship, this is.
You're for?
Election of India, my lord. Not State Election Commission has.
Oh, that, yes.
Lordship, the petitioners, both the petitioners are assistant professor of a government degree college. They have been drafted for election duty.
Yes, what is your stand? Why are you drafting them?
But in general, I think the election commission should be the appropriate.
Election commission is not a party, state election commission.
Lordship.
Impleted. Service?
Lordship, I have already filed.
Previous served.
Election commission is not a party. Oh, Millard, sorry, Millard, respond number 2.
Yes. Commissioner himself is a party actually. Anyway, none appears for the respondent number 2 despite service having been made previously.
May I be allowed to, Millard, assist Millard with one order, Millard? A similar nature of matter was taken up by Honorable Justice Amrita Sinha, where the allegation was that the teachers, the assistant professors, did not desire to work in a hierarchical manner. Millard, if Millard, I am allowed to.
Please place it, place it. The relevant portion, that read it out so that they can also hear. The relevant portion, please read out. The decision of Justice Sinha.
The total number of polling stations in the state is 2405, and there is requirement of 15,640 polling officers. There is a requirement of 3,128 presiding officers to be deployed. The presiding officers is the apex officer inside the polling station. There is no question disregarding the seniority of a Group A employee. If all assistant professors are exempted or their polling duty cancelled, there will be acute shortage of presiding officers and it would be difficult to manage the election procedure. The appointment of polling duty is done only in unavoidable circumstances. It appears that the submissions made on behalf of both the parties that the petitioners do not seek to complete exemption from the polling duty. The petitioners are agreeable to perform election duty, however, subject to maintaining the proper seniority and hierarchy in service. The Election Commission is accordingly directed to take necessary steps to ensure that hierarchy in service is strictly maintained at the time of the detailment of duty. A decision can be taken, Millard, by 4th of July.
Say, Election Commission was present there.
Millard, the State Election Commission was represented by Ms. Sonal Sinha and Millard, a few other.
Act order.
Lordship,
I'll pass my order, yes.
Lordship, I am
Ashu.
that footing, Lordship.
Learned counsel for the petition. Oh! Don't you even understand the intention of the court? You apparently don't. बोलते दिन. Yes. Yes. Argue.
Lordship, my question before this honorable court is whether the appointment letter is valid or not.
I am bound by justice in a judgment then. Learned counsel for the petitioner contends that the petitioners, comma, who are employed, who are senior of professors in government colleges, comma, being classified under group A equivalent to senior officers, comma, have been drafted to do election duty as polling officers by the State Election Commission without complying with the circular issued by the commission itself on February 16, 2010, comma, which stipulates that without specific reasons to be recorded in writing by the district election officer, comma, such appointments cannot be made in respect of group A or equivalent senior officers. Full stop. Next para. Learned counsel appearing for the state submits that in a similar matter, comma, a coordinate bench was pleased to observe that there is a dearth of polling officers in the entire state, and, comma, as such, comma, the petitioners therein were directed to do their election duties, subject, comma, however, comma, to maintaining the order of seniority. Full stop. Next para. However, comma, there are two distinctions. Please give a can you give a printout of that during the course of the day?
I will.
Please do that as soon as possible. I'll keep it on record. Next para. However, comma, there are two distinctions in the said judgment from the present case. First, comma, in the present case, comma, despite service, comma, the State Election Commissioner is not represented on several occasions. Secondly, comma, there is nothing on record to indicate that the petitioners insist upon their hierarchy being maintained. The dispute in the present case is not regarding maintaining the hierarchy in doing election duties, but regarding the drafting of the petitioners as a whole, comma, for the purpose of discharging the duties of polling officers. Next para. As such, comma, the present issue is distinct and different from that which arose before the learned single judge. Next para. Vide the communication number 464/INST/2009/EPS dated February 16, 2010, comma, the Undersecretary of the Election Commission of India clearly issued a directive on the subject of requisition of staff for election purpose. Next para. It was specified in the first paragraph thereof that the Election Commission of India had directed the chief electoral officers of all states / union territories to adhere strictly in true spirit to the guidelines while making appointments and requisitioning staff for the conduct of free and fair poll. Full stop. In the second paragraph thereof, comma, it is stipulated that the commission further desires that group A or equivalent senior officers, comma, including teaching staff of universities, comma, colleges, comma, etc., should not be drafted for polling duties in polling station premises without specific reasons to be recorded in writing by the district election officer, comma, where such appointments become unavoidable. Next para.
At the cost of interruption, my lord, this particular order is only upon the chief electoral officers, not on the state election commissions. Chief electoral officer is not a part of the state election commission.
Next para. It is seen from the array, ARRAY, of parties in the present petition that the chief electoral officer West Bengal has been implemented as respondent number 3 thereto but did not care to have himself represented
No, my lord,
despite.
no, my lord, no, my lord. I am appearing for chief electoral official and my lord, election of India, same, my lord.
So what is your stand in the matter?
My lord, right now, state election commission will submit, my lord. We have nothing to submit, my lord, in this regard.
Push up next para. Ki bola
He has no role, my lord, right now.
From the array of parties.
That the chief electoral officer has been impleaded as respondent number 3 therein, full stop there. Learned counsel for the chief electoral officer, comma, who is also appearing for the Election Commission of India, submits that the chief electoral officer has no role to play in the drafting of the petitioners. Full stop, next para. The game of passing the buck, is a common malady in our country. Full stop, unfortunately, comma, when high authorities are also afflicted with the same ailment, comma, it is unfortunate for the common litigant. Full stop, next para. In the present case, comma, the chief electoral officer through counsel, comma, bypasses his liability by saying that he had no role to play in the drafting of the petitioners as polling officers. Full stop, next para. Since the communication dated February 16, 2010 clearly stipulates that the chief electoral officers were directed to ensure that the stipulations therein are complied with, comma, in the absence of any action on the part of the chief electoral officer, comma, the State Election Commission had no business to draft the present petitioners, comma, all of whom are senior teaching staff of universities and colleges, comma, for polling duty, without complying with the circular dated February 16, 2010. Full stop. There is nothing on record produced by the respondents to indicate that either specific reasons for drafting the petitioners were recorded, or that the appointment of the petitioners were unavoidable. Full stop. The court cannot proceed on the basis of conjecture and surmise in calculating the total number of seats, total number of polling stations, and indicating as to what is the exact number of polling officers required, comma, more so in the teeth of the circular referred to above. Full stop. Hence, comma, there being nothing on record to justify the appointment of the present petitioners, comma, who are professors equivalent to Group A senior staff in colleges and universities, comma, cannot be the same cannot stand the scrutiny of law. Full stop. Accordingly, WPA 14861 of 2023 is allowed on contest, comma, thereby directing the respondent authorities to release the petitioners from election duty in the oncoming panchayat elections. Full stop. However, comma, it is made clear that nothing in this order shall prevent the respondent authorities or the chief electoral commission officer and or any other appropriate election authority to draft professors of colleges and universities for doing election duty, comma, subject to compliance of all necessary formalities, comma, including those stipulated in the notification dated February 16, 2010. Full stop. If such regulations and law are complied with, comma, there will be no impediment in such drafting being done with regard to such officers stroke professors. No address to cause, urgent certificate copies.
May I be permitted to submit one line, my lord?
Millard, this is an internal communication, Millard, between the election commission
Yes.
and their officer, Millard.
My lord, what happens, my lord? This chief electoral, my lord, this district.
Lordship,
My lord, district
new motion.
election-
Lordship,
Urgent certificate copy is my default order.
Dada.
Lordship,
Call on the next.
13.
there is similar matter, Lordship, item number 44, Lordship.
Yes, item 13. 13, who is appearing? None appears for the parties. Next month, adjourn till next month. Next. Board function করছে তো বাইরে?
According to 14, 15 and 16.
Yes.
I'm
14, 15, 16 একসঙ্গে বোর্ডে দেখাতে। দাও ফাইলগুলো দাও।
Have service has not been.
Service not yet complete.
My lord.
Accordingly,
Sir,
let the
notes.
matter stand adjourned till the next monthly list.
Ah.
Same order in all three. 14 to 16.
14, 15, 16. My lord.
Next monthly list job. No, next monthly list of August. আর monthly list of August লিখে দিন next month list হবে।
এটা কালকে রাখতে বলছে যে এখনই
17.
পিছন দিকে চলে যাচ্ছে।
Yes.
Yes, my lord.
Who is for the petitioner?
My lord, I am for the petitioner.
What is the matter?
Number 17, my lord.
Yes.
Just now we have received the copy.
Nothing doing. When was it served?
Service effective.
No, Mr. Mukherjee, I cannot help you. Yes, what is the matter?
My lord, I am for the private respondent.
My lord, 17, 20 and 21, all these writ petitions.
No, one by one I'll take up. Maybe I'll pass the same order, but let us take one. Yes. 17?
My lord, the petitioner is an admitted tenant, my lord. I have, my lord, attached, my lord, after, my lord, the rent receipts, my lord, were stopped, my lord, being issued. The petitioners, my lord, deposited their rent, my lord, in the rent control. My lord, on the pretext of, my lord, eviction, my lord, against one of the tenants, my lord, three writ petitions I have just mentioned, my lord, against one of the tenants, my lord, an eviction suit has been filed.
Petitioner.
Yes, yes, yes.
So let us proceed on that premise.
Against this petitioner, my lord, an eviction, my lord.
In these matters, file the other writ petitions prior to this, so that those are numbered previously, so that you can move the other matter first.
No, my lord, I'm moving on this.
That would be easier for you. Yes.
My lord,
So
against
your premise goes in this against this person, an eviction suit has been filed.
it has been filed.
Agreed.
No, just filed. Injunction, my lord, there's an order of status quo. And my lord,
Regarding position.
regarding, my lord, position, third party interests.
That would.
No.
My lord, in the meantime, my lord, the electric meter, my lord, disconnected.
Then
I, my lord, pray for a new meter.
not given.
My lord, not given, my lord, kindly sees, my lord, the object letter from CSC. That
Yes.
kindly comes to page number 14.
Split load.
Page 14, my lord.
14 years.
14, my lord, CSC has given this letter, annexing, my lord, the next page, the next letter. This letter, my lord, is of the from the private respondent's advocate, my lord, stating that there is a eviction suit. Kindly do not
Hereby
provide any-
restrained from transferring, subletting, etc.
etc.
You have been restrained from subletting.
Yes, I have been restrained. No third party interest to be created, my lord.
Yes, what do you say?
Yes, my lord. My lord, kindly peruse the page
You have
number.
held inspection, Mr. Mukherjee? Very good. Yes.
My lord, kindly
Do we like to do an inspection?
I understand. Yes. That's why I asked.
Yes, my lord. Kindly peruse the page number 12 of the writ petition.
Page 12, yes.
The last paragraph, paragraph
Yes.
number 2.
Right.
That we get electricity through the submeter at our tenanted portion, provided by the above person, have been enjoying the same with the family by paying the rupees 10 only per unit as per the consumption, and have been paying the electric charges.
You have disconnected that.
Yes, my lord. I am coming to that. I am coming to that.
Come to that directly. We start from there in an electricity.
My lord,
matter.
initially, there was a meter, submeter was there.
Don't want the story. Why have you done it?
My lord, they have stopped payment of electricity bill
It's
to
an
me.
independent action. You can litigate for.
Then also
but
they have
they are
beaten
entitled to
me.
elect-
They have also beaten me, my lord. And
Beaten me, beaten you.
yes, my lord, I am
Case.
yes, there is also proceedings is going on there. My lord,
Definitely.
my humble submission is that they have not paid the bill to me. That's why because I'm a veto.
Cause of action has no connection with section 43 of the Electricity Act. You know that? Even then you argue. Learned counsel for the petitioner contends that the petitioner is a tenant in respect of the property, full stop. An eviction suit has been filed by the private respondent stroke landlord. Full stop. In the same, an injunction order has been passed, comma, which does not affect the electricity connection of the petitioner. Full stop. It is further argued that when the private respondent disconnected the petitioner's supply, comma, which the petitioner was enjoying from a submeter from the meter of the private respondent, comma, the petitioner applied for a fresh connection. Full stop. However, comma, the same was not given by the CSC Limited CSC Limited on the ground that an objection thereto was given by the private respondent stroke landlady. Full stop. A copy of the objection was annexed to the communication of the CSC Limited as well as to the present writ petition. Full stop. Next para, learned counsel for the CSC Limited submits that the CSC Limited has not yet been able to inspect the premises for the purpose of ascertaining feasibility. Stop. Next para. Learned counsel for the private respondent submits that the private respondent is an aged lady and was physically accosted by the petitioner. Full stop. For such purpose, for such reason, comma, a criminal proceeding is now pending against the petitioner. Full stop. That apart, comma, an injunction was obtained by the private respondent in an ejectment suit preferred against the petitioner. Full stop. In the said order, comma, the court restrained the present petitioner and his men and agents from transferring, comma, subletting the B schedule property within bracket the tenanted property bracket closed to any third party. Full stop. Next para. Upon a perusal of the materials on record, comma, it is clearly seen that the injunction operates with regard to transfer and subletting of the tenanted property by the petitioner to any third party, comma, which has been restrained by the civil code. Full stop. Even without going into the question of such order, comma, the same, comma, palpably, comma, does not restrict the petitioner apostrophe S right as conferred under section 43 of the Electricity Act, comma, to have an independent electricity connection at the premises where the petitioner is residing. Full stop. As regards the grievance of the respondent number, private respondent, that she has not been getting due payments from the petitioner stroke tenant, comma, it is always open for the landlord stroke landlady to approach the appropriate forum, comma, be it the civil court where the ejectment suit is pending or the concerned controller, comma, for appropriate relief in that regard. Full stop. Next para. However, comma, the mere pendency of the eviction suit or subsistence of an injunction order therein of the nature as indicated above, comma, cannot restrain the petitioner from taking independent electricity connection, comma, more so since the previous connection given by the landlady has since been disconnected. Full stop. Next para. In such circumstances, comma, WPA 14924 of 2023 is allowed, comma, thereby is disposed of, comma, thereby directing the CS
kindly keep it pending manner because we have to see the feasibility.
আচ্ছা dispose of to করে দরকার নেই। The accordingly, comma, the CSC Limited is directed to hold an inspection upon prior notice to the petitioner as well as the private respondent for the purpose of ascertaining the feasibility of giving a new electricity connection to the petitioner at the premises in question. Full stop. A report in that regard shall be filed on the next returnable date upon circulation of advanced copies thereof to the learned advocates appearing for both the parties. Full stop. Such inspection shall be held within a week from date.
Manoj, kindly make it
Within a fortnight from date. Full stop. The matter shall next be listed on July 19, 2023, fairly at the top of the list for passing further orders.
Manoj, one more thing, Manoj, I'll seek for police help, Manoj.
In the event any resistance is offered to the CSC personnel in holding such inspection, comma, it will be open to the said personnel to approach respondent number 6, that is the officer in charge of the Cosba police station for adequate police assistance, comma, which will be given by the respondent number 6 by acting on a server copy of this order at the cost of the petitioner for the limited purpose of giving access to the CSC personnel to hold an inspection at the premises in question, comma, in particular at the existing meter board position.
I am for the state of West Bengal. The state is
Yes.
I'm grateful.
Thank
Your lordship will be pleased to, my lord, take up 2021, my lord, now, or my lord, I'll wait for my turn.
Please wait for your turn. I'll pass similar orders. 18.
Lord, 18, I am for the petitioner led by Mr.
The state, my.
led by
But
Mr.
I
Peter
appear
Sanjay.
for my lord.
Yes.
Number.
My Lord, the affidavit of service. My lord, the
2 to
matter
5.
is relating to rejection of offer of allotment of residential plot in Newtown. My lord, kindly see page 31. May I permitted to read the rejection letter, my lord?
31. Yes.
Paragraph number 1.
Hmm.
In the year 2004, the corporation invited application for allotment of residential plot in action area 2 and 3, Newtown, Kolkata, to the eligible individual And
What has not been complied with? Please come there, Mr. Mitra.
my lord, actually, they are saying that
What has not been done by them?
my lord, they rejected the offer
Rightly.
because my lord, the member candidates, name of the member candidates are not properly given.
Name of the member?
Candidates, 32 member
Where
candidates.
is your application? Have you annexed a photocopy?
Yes. My lord, page 13, my lord.
Page?
13, 1-3.
1-3, and where is the refusal? Give me that page number also.
My lord, that is page 31, my lord.
31 is a refusal.
No, man, it's not a case of refusal. May I just interdict? My lord, it is a case where allotment was made in favor of the cooperative housing society. The petitioner before your lordship claims to be the chief promoter of that housing society. The petitioner was required to disclose the names of the members of the cooperative society. At no stage of the proceedings, the petitioner informed the HITCO, that is the, my lord, the respondent number 2 to 5, the details of the members. Now, my lord, what happened thereafter? This allotment was made in 2006. Payments were made by the petitioner. Till 2016, my lord, we did not get any response regarding who were the members of this cooperative society. Accordingly, my lord, we issued notices that you give us the list of members and also give us the details of the members. Hearing was given. In the hearing, your lordship will find that paragraph 9 of the impugned letter. My lord, it has been clearly indicated. I have also got the minutes of the meeting. But this is, my lord, first of all, my lord, the petitioner is approaching the court, challenging this termination after a lapse of 6 years. This is a 2017 termination now challenged in a case of contract.
What has been done by you?
Well, I have terminated and I have forfeited.
That is within the provisions.
That is within the provisions.
Now, my lord, I have the copies of the.
Why the late challenge? What is the reason for the delay? On that ground itself, it should go.
Actually, my lord, the petitioner was not properly advised that what should be done. They time and again contacted with the authorities, but
it's not a question of authority.
On delay ground,
may I pay for a short passover? My
no,
lord?
not now. Learned counsel for the petitioner moves the present writ petition alleging irregularities on the part of the respondent authorities, comma, in rejecting.
It's a question of terminating the allotment. It's
Wait,
cancelling the
allotment given to the concerned cooperative society, comma, of which the petitioner claims to be the chief promoter. First up, next para. It is alleged by learned senior counsel appearing for respondent numbers 2 to 4.
2 to 5, madam.
2 to 5, that the allotments were originally done in the year 2006. 2006, full stop, till 2016, comma, no list of members was handed over on behalf of the petitioner or the cooperative society, namely KGN, Cooperative Housing Society, within bracket proposed, bracket closed. Full stop. After waiting for so long, comma, a hearing was given to the petitioner. Full stop. However, comma, subsequently on the grounds stipulated in the cancellation order, comma, as communicated on September 18, 2017 to the petitioner, comma, the membership of the cooperative society was cancelled. Full stop. Next para. It is seen from a cursory perusal of the impugned communication containing the order of cancellation dated September 18, 2017, within bracket annexed at page 31 of the writ petition, bracket closed, comma, that sufficient reasons for the cancellation were given by the petitioner, by the respondent authorities. First of that apart, comma, elaborate hearing was given and reasons were given before passing the said order. Full stop. Hence, comma, I do not find any illegality or irregularity in the decision-making process of the respondent authorities in cancelling the petitioner's prayer, in cancelling the appointment of the cooperative society as a member
মানে allotment, my lord.
allotment to the cooperative society as a member for non-submission of documents, comma, misrepresentation of facts, etc. Full stop. Next para, that apart, comma, the respondent authorities are justified in arguing that the petitioner waited for so long as about 6 years before challenging the impugned order of cancellation. Full stop. It transpires that the order of cancellation was passed on September 18, 2017, and the present challenge has been taken out only on June 22, 2023. That is almost about 6 years thereafter. Full stop. There is no plausible explanation or reason given in the writ petition for causing such inordinate delay in taking out the writ petition. Full stop. Next para, although learned counsel for the petitioner seeks to justify the delay on the ground that the petitioner was ill-advised, comma, there is nothing on record even to substantiate such pleadings, comma, let alone prove the same. Full stop. Accordingly, there is no ground for interference both on merits and on the ground of delay in preferring the writ petition, comma, which defeats the principle of equity which is implicit in the writ jurisdiction. Full stop. Accordingly, WPA 14931 of 2023 is dismissed on contest without any order as to cost. The affidavit sir is filed today, be kept on record. Sorry, Mr. Yes, next. Use the mic. Either start the matter
On adjournment, my lord, because of the fact, on adjournment, my lord.
on the
to
prayer of the
complete the
petitioner. The
facts.
matter is adjourned and shall next be listed in the monthly list of August 2020. Next.
Twenty.
2021 similar order.
Similar matter, it will be mana similar.
Private respondent.
My lord, only my lord.
For this. No private respondent here.
The same private respondent.
Same private respondent, same order.
Madam,
Yes.
only one thing, my lord, on item number 17, my lord, one thing I forgot. If my lord may kindly add in all three matters, my lord, the direction to break open the padlock, my lord, if there is any.
There, my instruction is my lord, there is.
17 টা কি আপনি নিয়েছেন? 17 টা তাহলে একটু 17 এর অর্ডারটা যা হয়েছে পুলিশ যেখানে হেল্প দেবে বলেছি ওখানটা শুধু অ্যাড হয়ে যাবে যে রেসপন্ডেন্ট নাম্বার সাচ এন্ড সাচ শ্যাল গিভ মানে পুলিশ আর কি শ্যাল গিভ সাচ অ্যাসিস্ট্যান্স এট দি কস্ট অফ দ্য পিটিশনার comma if necessary breaking open padlock or any padlock or other hindrance comma if put up to resist the CSC personnel from having such access.
I'm grateful.
Same order in 20 and 21 also.
My lord, there in 2021, there is no injunction.
My lord, 20 and 21, my lord, I just need to point out one thing, my lord. That same letter that was in 20, that was in item 17, that has been, my lord, annexed by CSC in this.
But injunction has not been granted in those matters.
Not.
No eviction suit has been filed.
That is in
তাহলে এটা অন্য অর্ডার করে দিন 2021 এর সিমিলার অর্ডার হবে The petitioner is a tenant in respect of the premises in question. Full stop. On the objection of the private respondent stroke landlord, comma, the CSC Limited has not yet been able to give electricity connection to the petitioner or to hold an inspection to ascertain feasibility of giving an independent connection to the petitioner. Full stop. Next para. It is well settled that any person in settled possession of a property is entitled under section 43 of the Electricity Act 2003 to get an independent electricity connection. Full stop. However, comma, in order to ascertain the feasibility of giving such connection, comma, the CSC Limited is required to hold an inspection. Full stop. Accordingly, the CSC Limited shall hold an inspection at the property upon prior notice to the petitioner as well as the private respondent for the purpose of ascertaining the feasibility of giving an independent electricity connection at the premises. Full stop. The CSC Limited shall file a report on the next returnable date upon circulation of prior copies to the learned advocates for the petitioner and the private respondents. Full stop. In the event any obstruction is faced by the CSC personnel while doing so, comma, it will be open to the said personnel to approach the respondent number 6, that is the officer in charge of the Cosba police station, who, on such approach, will provide adequate police assistance at the cost of the petitioners to the CAC personnel to ensure that the CAC personnel have proper access to the existing meter board position as well as the premises to hold such inspection. Full stop. If need be, the police personnel shall be at liberty to break open any padlock or other hindrance, which might impede the CAC personnel from having access to the property for holding such inspection. Parties shall act on a server copy of this order. The matter shall next be listed on
19th minor, 19th minor is stated.
19th. Very good.
We'll do it by fortnight minor as
on July. আচ্ছা এটা রিপোর্টটা বললাম যে shall hold an inspection within a fortnight from date করে আর রিটার্নেবল হচ্ছে 19 July 19 2023.
I'm grateful.
Thank you. What? 22.
Well, the availability of service be kept on.
No. সব করাতেই মাধববাবু এফিডেভিট সার্ভিস কেপ্ট অন রেকর্ড সবাই তো অ্যাপিয়ারও করেছে Yes, Colin.
22.
22.
Lordship, I am for the petition.
Yes, Mr. Pal, what is your
I am for the respondent number 6.
Lordship, it's a,
who is the main respondent contesting? You are for the yes. Yes, Mr. Pal, what is the matter?
Lordship, I have challenge, threefold of challenge. First thing, Lordship, whether in the corrigendum main clause can be substituted or not. And the corrigendum issued, that is shorter the competition and it's a tailor-made condition, Lordship. And number 3, Lordship, I have made a representation which has not considered till date, Lordship. Lordship, finally, turn page 68, the tender, Lordship, which starts from 70, Lordship. 68 is a
70. Should I go to 70?
70. Lordship, pre-bid meeting and clarification, second clause.
Yes, yes.
All intending bidders are advised to visit CPP. CPP means Central Public Procurement Portal and CNCL, Chittaranjan National Cancer Institute, website regularly till the finalization of e-tender for update information related with this e-tender. The clarification issued by CNCI Kolkata shall be treated final and bidders are advised to submit their bid after incorporating pre-bid clarification and amendment before the closing date of e-tender submission given. So clarification and amendment, not substitution, Lordship. Lordship, kindly turn, Lordship, page 76, the clause which has been amended.
Yes.
10, Roman 10, Lordship.
10.
Participating bidder companies required to upload duly signed and attested legible scanned copies of work orders, performance report, relevant documents regarding providing similar nature of patient diet kitchen in government hospital. Lordship, similar nature, Lordship, of not. Patient diet kitchen, that means patient diet kitchen experience. In the government hospitals, other reputed hospital more than 200 bed, preferably accredited or clarified institution for 3 financial years, Lordship. Last 3 financial years. Chronological order has been mentioned, Lordship. Lordship, kindly turn 148, the clarification, amendment. Collision now, 148.
Yes.
Minimum 1 number previous work order contract agreement of handling similar nature of, Lordship, patient diet kitchen in any cancer hospital. It's specified. In main, there is no specification that cancer hospital because it's cooked diet, whether I have got the experience of supplying cooked diet, patient cooked diet. And now it is specified cancer hospital. And Lordship, it has taken for last 5 financial year. So it narrow the competition, Lordship. Because diet, if Lordship, I am annexed a diet given by them, the proposed diet.
Do you say they don't have the liberty to do that, Mr. Pal? Because
the mention it is the pre-bid meeting for clarification and amendment.
The time left was sufficient for participation.
Lordship, 5 years.
No, that is all right, but Lordship, the time left was sufficient.
Time left.
I mean, now it's their option.
No,
it's
Lordship,
as good as floating a new tender.
Lordship, amendment that is cannot be done, Lordship. Is only for clarification and amendment.
No, Mr. Pal, suppose today,
Yes.
if they issued a new floated a new tender, They could have put this in.
And if it's a tailor-made condition, I have to write the challenge at him. It's a tailor-made condition. Only cancer
Another
hospital.
challenge, but
Yes.
regarding your first point that in clarification, the main thing cannot be changed. They could have very well floated a new tender today.
It is not new tender, Lordship. It's a corrigendum to the earlier tender.
How are you affected by that?
Lordship, I am affected because it's specified that cancer hospital.
That is another aspect, but they have a right because this is for cancer hospitals only.
Kindly see the diet.
The diet may be different.
Same. I have annexed the diet, Lordship. Both diet.
Can we go into that question?
Lordship,
Cancer diet, whether that is different.
Lordship, they have annexed.
Acha, very well.
They
Let
have
us see.
checked, Lordship. The diet, food item, Lordship.
So you have checked up the diets are
Yes,
similar.
yes, Lordship.
So you say they cannot stipulate cancer hospital
And
this
5 years.
5 financial years. Why not?
Lordship,
Is
because
there
they
an
have-
option?
In the main tender, they have mentioned 3 years. What is the reason for 5? What is the reason for
I did
amendment?
not give that.
Because Lordship, in PB meeting, there was no suggestion.
Today they can float a new tender by incorporating these clauses.
Lordship, they can float it. But
See, it's as good as that
No, this
instead
is
of
not that.
wasting public money.
no, Lord, it's not that, Lordship, because if it is specified cancer hospital, then it cannot be, Lordship. Because it specify the cancer hospital narrow the competition. Because the diet are same, Lordship.
As very well, let us see the diets also.
Lordship. that
Give me
is
the
that
page
is
numbers, Mr. Pal.
Lordship, food record, Lordship, page 106 to 109, Lordship.
That is other
Cancer
hospitals.
hospital.
And what about the ordinary hospitals?
Lordship,
General?
government hospital, page 166 onwards.
So you have checked up both are same.
Forward. More or less, Lordship, bhat, dal, vegetable, rice, dal, vegetable, food,
Usual.
fish.
Very yes.
Normal. It's a normal diet, Lordship. All are normal. There is no bread, butter, omelette, egg, same.
And this is your bread butter also.
Lordship, this is my bread, butter, Lordship.
Yes. So these two main grounds, these three main grounds.
Another thing, Lordship, in the
Why do you say tailor-made?
tailor
of the-
because it is specified for cancer hospital. Those who are supplying for cancer in last 5 years, they will only be eligible. But my experience will not create anything, Lordship, because I have got the experience for 10 years in government hospital, catering same food. And Lordship, another thing, Lordship, I have made on representation, page 146, Lordship.
Do you have the right to make that?
Lordship, in the pre-bid
Under the
meeting, Lordship, I have
Pre-bid, yes.
I have stated that in pre-bid meeting, I have raised that point. They told me that you give a representation, we shall deal with that. And Lordship, page 75, the clause, which I want to clarify, Lordship, page 75. Clause 2, Roman C. Sign and scan photocopy of valid registration incorporation certificate of the firm.
This is a different issue.
This is a different second limb is our papers. Sign and scan photocopy of valid registration / incorporation certificate of the firm, Lordship. Lordship, I have asked whether it's a registered partnership deed. If a partnership deed submitted, that should be registered under Partnership Act or not. That my
In
clarification.
the pre-bid meeting, what happened? This was not clarified.
No, see, they told me that give a representation, we shall consider it while issuing corrigendum. But that has not considered.
That was verbally said.
Lordship, that has I awarded, Lordship. In the writ petition, I have awarded that.
And in your representation also.
Lordship, representation, Lordship, kindly page 146.
5 feet, 5 feet. Very well.
146.
146 I've seen.
Representation, Lordship.
Yes.
Exactly same thing I have given.
Yes, yes, yes. Yes, what is your?
I am for respondent number.
Yes, yes. What is your answer to these?
Firstly, your Lordship has said.
Before starting to hear you, should I take my break, 10-minute break?
Lordship.
I'll take that and so that there is continuity. I'll take my 10-minute break and come back immediately.
208. In similar circumstances, Lordship, coordinate bench pass an order, Lordship. Page 208, Lordship. The ratio, as per my submission, the ratio will be applicable in this case, Lordship. Lordship, there is a clause, Lordship. Got it, Lordship? First page, 208. Clause 1B, credential for providing similar service in the ESIS hospital in India, having at least 300 beds. That means it was specified experience should be ESI hospitals experience, Lordship. And that has been turned down, Lordship. Lordship, last 212, Lordship. WPS surgeon is accordingly disposed of with a direction on the respondent to make appropriate changes to the consult clause only to the extent disputed in the present petition, namely the requirement of participation only in ESI hospital. The respondent shall be free to call a fresh e-tender after bringing about the changes, Lordship. And Lordship, it has held in this order, Lordship, that it is a tailor-made condition, Lordship.
Yes, Mr. Chakravarti. Sorry.
Lord, your Lordship, this is the government's right to enter into contract under Article 299 of the Constitution.
Yes.
Here is the contract which is going to be floated. There are three persons involved in this case: the principal, the agent, and the beneficiaries. The beneficiaries are the patients, the cancer patients. Therefore, it comes within the zone of consideration of the special provision of the contract act. Now, my lord, the agent under the special provision of the contract act cannot dictate terms upon the principal to go into certain conditions for his benefit. This is a well-settled principle of law, and the right of the agent comes only when the contract is accepted, a letter of intent is issued, and agreement is entered in. Therefore, at this stage, the petitioner has no right to dictate terms to the principal that this is the way it should be handled, and these are the terms. These are the questions not considered in the judgment referred to, and that is an interim order. This question, there is no ratio in the judgment. I don't like with great respect to this person. Thirdly, my lord, your lordship will kindly appreciate.
No, that was not interim. That was final order.
Yes,
The
but there is
petition
no ratio. The only point that has been decided there is the question
arbitrary.
of ESI. Yes.
Yes.
Now,
No nexus with the
yes.
purpose.
Now,
That was the issue.
Why is the petitioner's infringement of fundamental rights or any other legal right that is not been treated? No grounds, specific grounds are there. There is no infringement of either the fundamental right to business, benefits considered under Article 19, that is subject to some restrictions, and that is not an unfettered right. Now, there is Supreme Court has time and again on this issue as directed. This is the possibly the latest one. On the question of entering into contract, preparation of terms of contract.
Side to the
In the projects, yes.
Online. Supreme Court 336.
2022.
Court cases online. Court 336. Kindly first come to paragraph 13 of the judgment.
Yes, 13.
The essence of the law laid down in the judgments referred to above is the exercise of restraint and caution. The need for overwhelming public interest to justify judicial intervention in matters of contract involving the state instrumentalities. The courts should give way to the opinion of the experts unless the decision is totally arbitrary or unreasonable.
No, para 13 you said.
13, sir.
13.
This court sounded a word of caution.
I'm sorry. I'm not referred to the paragraph 20.
Acha.
The earlier judgment that has been referred.
By sense of law, yes.
Yes.
Very well. 20 I've got.
Yes.
20 of the earlier judgment.
The essence of the law laid down in the judgment referred to about is the exercise of restraint and caution. The need for overwhelming public interest to justify judicial intervention in matters of contract involving the state instrumentalities. The court should give way to the opinion of the experts unless the decision is totally arbitrary or unreasonable. Court does not sit like a court of appeal over the appropriate authority. The court must realize that the authority floating the tender is the best judge of the requirements. This is I am relying on, and therefore the court's interference should be minimal. The authority which holds the contract of tender and has authored the tender documents is the best judge as to how the documents have to be interpreted. If two interpretations are possible, then the interpretation of the author must be accepted. The courts will not only interfere to prevent arbitrariness, irrationality, bias, malafidity, or perversity with the approach in mind. We shall give it. Now, your lordship will kindly come to the next page, paragraph 17 of this judgment.
Yes, 17. Yes.
Para 17 of the judgment.
Therefore, the position of law.
Yes. And then finally, my lord, in para 23, para 23 of the judgment, the earlier judgment was referred to in the judgment. Para 23, this is
To approach should not be to find fault with magnifying glass.
para 23 says, in view of the above judgments of this court, the court should refrain itself from imposing decision over the decision of the employer as to whether or not to accept the bid of tender. The court does not have the expertise to examine the terms and conditions of the present day economic activities of the state, and this limitation should be kept in view. Courts should be even more reluctant in interfering with the contracts involved in technical issues as there is a requirement of the necessity expertise to adjudicate upon the issue. The approach of the court should be not to find fault with the magnifying glass in his hands. Rather, the court should examine as to whether the decision-making process is after complying with the procedure contemplated by the tender conditions. If the court finds that there is total arbitrariness or that the tender has been granted in a maleficent manner, still the court should refrain from interfering in the grant of tender, but instead relegate the parties to seek damages for the wrongful execution rather than to injure the execution of the contract. The injunction or interference in the tender leads to additional cost on the state and is also against public interest. Therefore, the state and the citizens suffer twice, firstly by paying escalation costs and secondly by being deprived of infrastructure for which the now these judgment and the ratio decided in the judgment were not considered by the single judge, which my relevant. Therefore, my lord, on this whether simple question is before your lordship, whether the petitioner can ask for his beneficial conditions at the time of floating of it. And that is whether it is arbitrary, whether the authority floating a tender has a right to impose condition because he is the best judge and he is the best person. And it hardly not here. I do not know whether my landlord has verified food which is supplied to government hospitals.
Yes, regarding that also, that is one of his arguments. He says he relies on page 106 to 109 and 166 onwards. He says those are substantially the same food, the basic things. Here it is bread, chira, suji, dal, vegetable, the usual things.
Not in any event, he has made an application, representation for consideration.
No, that is on a different aspect, Mr. Chakraborty. That is on probably some other aspect. He sought a clarification regarding something. He sought a clarification regarding something else. What is the page of your representation, Mr. Pal? 146, right? 146. Yes, 146. Representation, I can very well direct to you to consider that. He has sought a clarification. You can give that clarification, whatever. But regarding that,
if I impose certain condition before at the time of floating of a tender, how is it arbitrary? I am asking the question. And how does it come?
what about I am bound by the previous court's judgment? How do you distinguish that?
Yes, because
I'll have to distinguish that because I am bound by coordinate bench also, unless I hold.
Taken into consideration Supreme Court's observation as regards imposing of certain conditions at the time of floating of tender. The
But-
judgment simpliciter has
No, the judgment considered Michigan Rubber and Tata Cellular. I also looked that up. Internal page 4 of that judgment, the respondents rely on your side relied on Michigan Rubber and Tata Cellular. The court does not have the expertise to correct an administrative decision and that the terms of the cannot be open to judicial scrutiny. Same principle.
Last para. On the same page, last para.
Yes, last para is the ratio of that. But the judgment, the same
Analysis.
propositions have been considered by the court. That is the difficulty, Mr. Chakraborty. Why am I not bound by this?
This is a judgment in respect of ESI hospital. This is a judgment. in
Yes, the clause was ESI.
respect of- Just read the judgment. There is
No,
200 pages.
two things are there, Mr. Chakraborty. You read it, but you have to keep in mind two things. This tender here, that was regarding ESI. If you see the first paragraph of that, page 208, I'll just guide you on that, Mr. Chakraborty. Then you read your entire thing. Page 208 says the petitioner is agreed by a clause such and such for selection of an agency for supply of cooked diet to the indoor patients at ESI hospital. So that tender was for an ESI hospital, but the court held in the last paragraph of page 211 that in the present case, scrutiny's limited condition has been found to be arbitrary by reason of lacking a discernible nexus between the requirement and the scope of the tender. There also it was for ESI hospitals. But this stipulation that he has to have served an ESI hospital, that was set aside, saying it is arbitrary.
Come to page 210 of the judgment.
Yes,
From the top.
right.
Upon carefully considering the clause, this court is of the view that the requirement of 300 beds and continuous service for 5 years.
5 years not accepted by the court. I'll ask Mr. Pal that question. I've checked that.
That is the finding.
Yes.
Is not accepted by the court or struck down.
300 beds and 5 years are reasonable. That is the question I'll put to Mr. Pal, Mr. Chakraborty. That 5 years, the same challenge was turned down by the court. But on the third point, third requirement was ESI.
Requirement, however, of providing such service on.
That was set aside.
There is attention. The requirement of providing service on the ESI hospital must have a contextual and purposive link to the service which is provided. In this case, the service is for providing food diet to the patients in the hospital. Hence, there can be no justification in restricting the eligibility criteria to only those bidders who have provided food diet to ESI hospitals.
So one point is in your favor. One point is in your favor. ESI hospital, ESI is not the name of a disease.
Yes,
So ESI hospital treat all sort of patients. So it need not be restricted to ESI. But cancer is a particular disease, and for that, but whether that has any nexus with the food to be provided.
Yes, my lord.
After that,
Mr. Kolwal Bose would be the best person to say whether you won't be knowing here. No, he's not in court. You won't be knowing these things, Mr. Chakraborty. These are beneath your dignity.
Lord, kindly consider this also. Cancer patients, what kind of foods they require? It cannot be same food every day.
Neither you know nor I know. So that's why your principle applies. Your NG projects principle. Court does not have the expertise.
Cancer patients require every day's requirement of checkup and supply of foods. It may be altered, it may be changed.
No, that in all cases.
Because the question of whatever I have learned about the cancer patients is the supplementation of protein and other things along with medicines. It cannot be said that this type of particular food has to be supplied in the as it is done in government hospitals. There cannot be one of these definitions. What my learned.
My lord, I want to add only two things, my lord. As per the pre-tender condition, my lord, kindly come to page 70.
Lord, may I give?
No, tell Mr. Chakraborty he'll submit. He's leading you in this matter. So tell him he'll submit.
No, she's appearing for the cancer director cancer list.
Oh, you're not for the same authority.
My
Oh,
lord,
then
I would
obvious,
say
please,
It is
please,
an
please.
autonomous body under the Ministry of Health.
No, definitely, yes. Now, I was wondering whether there is a political tie-up also after Mr. Chakraborty is appearing for the state. That I was wondering.
She is for cancer hospital. It's governed by the Union of India. Cancer hospital.
No, but Mr. Chakraborty appeared for?
Government of India. Government of India.
Ministry of
That's all right, yes. So yes, what are the 2 points?
Page 70, my lord.
70?
Page 70 of the petition, 70.
Yes, 70.
My lord, all intending bidders are advised to visit CPP portal and CNSI website regularly till the finalization of e-tender for updated information related with this e-tender. The clarification issued by CNSI Kolkata shall be treated final, and the bidders are advised to submit their bid after incorporating pre-bid clarification and amendment before the closing date of e-tender submission given at e-tender schedule. So, my lord, as per this condition, we can amend or we can add any condition. My lord, now kindly come to the corrigendum that has been issued, that is at page 148. What we have added, my lord, only we have added that experience in any cancer hospital should be there. My lord, cancer patients are special patients, my lord. They has to be a chemotherapy, radiation, my lord. For that, nutritional diet is required. My lord, kindly come to page 148. After this corrigendum has been issued, we have extended the time also. The last
Yes,
date of
regarding that,
submission-
he has nothing to say.
That we have extended. Today is the last date of submission of the tender, my lord.
In any
My
event,
lord,
if he,
my lord, I am also relying upon Shilpi Construction Contractors versus Union of
Also,
India,
yes.
paragraph 20.
the ones which were left out before Justice Bhattacharya are being cited before me. So to complete the thing, Shilpa and NG projects were left out there. The others were cited.
My
Yes,
lord,
very
my humble submission is that it is for the cancer patients, my lord. As such, my lord, special nutrition is required, and they does not have that experience, my lord.
Yes, Mr. Pal. You have a bad case in this. And
Lordship,
other than Justice Bhattacharya's case, this is worse.
Lordship,
Because of the reasons which Mr. Chakraborty also
so
argued.
I have pleaded that my fundamental right to right.
Regarding
to
5
business-
years, Mr. Pal, that
Lord,
goes
please.
against you because the previous bench. Now, regarding this ESI,
Lordship,
as I
Lordship,
clarified,
Lordship, that is why I have annexed the diet schedule.
can we
Yes.
go to that extent? That is a difficulty, Mr. Pal,
Lordship, that
because
is the diet
certain
schedule.
supplementations may be necessary.
No, Lordship, that is the detailed schedule is there. We have to, the successful bidder has to supply that food only. And the price has been fixed for supplying those items, Lordship. Nothing there, Lordship. This is what the, my lord, respected learned friend said that is as per his opinion, not the opinion of the tendering committee, Lordship. Tendering committee opinion reflects in their diet schedule, Lordship. That is more or less similar to the diet schedule fixed by the state government. Rice, dal, vegetables, fish. Quantity is same. More or less same, Lordship. Kindly, Lordship, see. Egg, bread, banana. Quantity is also same. Lunch, dinner, same. Nothing special,
Lunch
Lordship.
dinner has to be same. Sir.
Nothing special, Lordship. For cancer patient, nothing special. Lordship, that is why the initial tender, it was stated that the experience for supply of cooked diet in any government hospital. And Lordship, kindly appreciate, Lordship, last 5 years experience in cancer hospital means those who are supplying in cancer hospital, only they can participate. This is tailor-made, Lordship. This is tailor-made, Lordship. And this is arbitrary, Lordship. Because they restricted for participation of others, Lordship. I have experience, more experience than this person maybe, but I will be restricted because I do not have the experience of supplying cancer. Because last 5 years, the person who is supplying, then he will get the payment.
Mr. Pal, the difficulty lies elsewhere. You have a point there when you say that the food, you have to supply cooked diet. You are not to treat the patients. You may have a point there. But the question is how far the court can go into that. Because the employer's discretion has been reiterated by
Lordship, there
Supreme
has
Court
been-
in all the judgments.
Coordinate bench has stated that.
So
Not
if they
not
say that
change the terms, not change the term. Lordship, the coordinate bench has specifically stated in this way. Lordship,
the
that is why
coordinate bench has specifically proceeded on the premise
in the
that it was arbitrary because ESI cannot be a determinant.
that is the
ESI hospitals and
Lordship, if Lordship accept that ratio, that cancer hospital for last 5 years restricted.
no,
only
that
for-
was not held by her
Lordship,
leadership.
only-
Please come to page 210
Lordship,
and page 211
11,
actually.
Lordship.
11, right.
In
If
the
you please
present
read that
case,
out,
the
Mr.
court
Pal.
does not intend to change any of the terms and conditions of the tender.
Which paragraph?
Last paragraph.
Yes.
In the present case, the court does not intend to change any terms of the condition of the tender in question. The scrutiny is limited to the act of restricting the competition only to those who have served ESI hospital.
Obviously.
That is your Lordship scope.
No, restriction of competition is obviously there.
Yes, Lordship.
If it is
In this case also, last 5 years experience in supplying cancer hospital. Do there any contractor is there? No. Because only those contractors who is supplying last 5 years, he only can participate, not anybody else. That is the point, Lordship.
Learned counsel for the petitioner, learned counsel for the petitioner contents. Please take your seat. That no seat. Yes. Learned counsel for the petitioner contents that a corrigendum has been issued to a tender floated by the respondent authorities in respect of supply of cooked diet to a particular cancer hospital. Full stop. Next para. It is contended that the terms of the corrigendum virtually seek to bring about a sea change in the primary clauses of the original tender, comma.
May I take leave, Lordship? One thing, Lordship, in favor of me, Lordship, then Lordship can extend the time for submitting the Lordship. Lordship, may I take leave?
But no, but Mr. Pal, I cannot do that. I cannot do that because the others would be affected. Other people would have got the.
It is the last date, and this clause barred me to participate, Lordship. Lordship, 2 days extension, I shall.
2-3 days has to be for all then.
All, Lordship. Because the e-tender.
Tender, my lord.
So
There's time, we can
they have to publish a notice, Lordship.
E-tender, Mr. Pal, you can. What is the last time?
2.
2 they cannot. 2 is very difficult.
Lordship.
I don't think it is 2. I think it is 4. My lord, shall I take instruction, my lord?
Please check up in the meantime. What is the last?
Go out.
Mr. Paul, these are soft copies. Ask your client to be ready in the meantime.
Lordship, want to do this because
When you go out, please ask your junior to tell him to be ready.
He has to, Lordship, if file an affidavit, Lordship.
He has to be ready with these. You are taking a chance in the lead petition, Mr. Paul.
Only 3 days I am paying for. Only
No,
3.
not it cannot be for one particular person.
No,
The
Lordship,
others will be affected.
all, Lordship, because so many persons is obstructed by this laws.
Acha, very well. I'll consider that.
Lordship, may I take leave?
Yes, yes, absolutely. See change in the full stop. It is contended that although the original tender stipulated that the previous experience of similar work had to be for the last 3 financial years, comma, the said period has been increased to 5 financial years in the corrigendum. Full stop. Secondly, comma, whereas the original tender contemplated the previous work experience to be of similar nature for supply of patient diet work orders, comma, the corrigendum restricts such work in respect of cancer hospitals only, comma, thereby preventing several operators and contractors from participating in the bid process, comma, in order to curtail competition. Full stop. Next para. It is contended that the restriction in question does not have any conceivable nexus with the purpose of the tender, comma, since the cooked diet contemplated in case of original, in case of other hospitals is similar to that of cancer hospitals. Full stop. It is further argued that the corrigendum, comma, if allowed to come through, comma, would tantamount to making the tender terms tailor-made, comma, to suit particular contractors who have worked in similar projects only in respect of the cancer hospitals and, comma, that too, comma, for the last 5 years. Full stop. Next para. It is argued that such change at the 11th hour ought not to be permissible. Full stop. Next para. Learned Counsel also submits that the petitioner was made to believe in the pre-bid clarification, in the pre-bid meeting, comma, in which the petitioner participated, comma, that the petitioner was to seek a proper clarification on certain issues by way of a representation. Full stop. Such representation has been filed on June 7, 2023. Full stop. However, comma, no reply thereto has been given by the respondent authorities as yet. Full stop. Next para. Learned Senior Counsel appearing for the Union of India submits by placing reliance on Silpi construction contractors reported at 2020-16. You cited this. Achana, sorry, by placing reliance on NG Projects Limited versus Vinod Kumar Jain and others, reported at 2022 SCC Online SC 336, that the essence of the law laid down in the judgments considered therein is the exercise of restraint and caution, semicolon, the need for overwhelming public interest to justify judicial intervention in matters of contract involving the state instrumentalities, semicolon, the courts, comma, it was held, comma, should give way to the opinion of the experts unless the decision is totally arbitrary or unreasonable. Full stop. Next para. Further, comma, it is argued that the tender issuing authorities are the best judge as to how the documents are to be interpreted. Full stop. If two interpretations are possible, then the interpretation of the author must be accepted. Full stop. The court will only interfere to prevent arbitrariness, comma, irrationality, comma, bias, comma, malafide or perversity. Full stop. Next para. Learned counsel appearing for the tender issuing authorities contends that the nature of diet to be provided to cancer patients, comma, who are exclusively treated in the cancer hospital, comma, has certain distinctions from other ordinary patients. Full stop. As such, comma, the yardstick of having supplied cooked diet to cancer hospitals exclusively in the previous experience, comma, which is one of the criteria in the corrigendum, comma, has absolute justification and is directly connected with the purpose of the tender. Full stop. Insofar as the stipulation of 5 financial years is concerned, comma, it is submitted that the same falls within the domain of the tender issuing authorities. Full stop. Next para. Upon hearing learned counsel, comma, it is seen that the petitioner has relied on a coordinate bench judgment delivered on December 15, 2022 in WPA 27778 of 2022, where a similar clause pertaining to previous experience regarding ESI hospitals was set aside by the learned single judge on the ground of arbitrariness. Full stop. Next para. However, comma, as rightly pointed out by learned counsel for the respondents, comma, there are specific distinctive features between the said case and the present one. Full stop. Although, comma, in the said judgment, comma, the court considered a clause pertaining to supply of cooked diet for indoor patients at ESI hospital, comma, Baltikuri, comma, Howrah, and the clause set aside was also pertaining to prior experience of supplying such food to ESI hospitals, comma, the yardstick as stipulated in the said judgment was different. Full stop. The learned single judge held that the purpose of floating a tender, particularly by government entities, is to ensure transparency. In the said case, full stop there. In the said case, comma, the court specified that it does not intend to change any of the terms and conditions of the tender in question, but that the scrutiny was limited to the act of restricting competition only to those who have served ESI hospitals. Full stop. Next para. However, comma, the restriction to competition has been highlighted by learned counsel for the petitioner in the present case, semicolon. However, comma, the key expression, KEY, key expression in the said judgment was actually contained in the next sentence, comma, which stipulated that the condition was found to be arbitrary, তারপর double inverted মধ্যে, by reason of lacking a discernible nexus between the requirement and the scope of the tender, double inverted clause, full stop. Taking the said judgment on its intrinsic value, comma, the yardstick put in the said tender was that the participant in the tender process had to have served previous ESI previously has to have served previously ESI hospitals only. Full stop. However, comma, the expression within double inverted ESI is merely pertaining to a particular class of employees, comma, to whom the hospital facilities are available as perquisites of their employment. Full stop. The said expression, comma, however, comma, does not have any connection with the particular disease sought to be treated in the hospitals or the particular type of patients vis-a-vis their ailments. Full stop. Next para. However, comma, in the present case, comma, within double inverted cancer, double inverted close, is the name of the particular disease which is exclusively treated in the hospital in question, comma, for which the impugned tender was floated. Full stop. Hence, comma, it cannot be said that the particular nutrition to be provided to cancer patients, comma, being treated in the said hospital, comma, has a direct nexus with the type of food supplied and, comma, consequentially, the previous work experience of the contractor in similar sphere of work. Full stop. Pen. Sphere of full stop. A general experience in working in other hospitals treating all diseases may be on a quite different footing than the food supplied specifically to cancer patients exclusively treated in the present cancer hospital. Full stop. As such, comma, it cannot be said that there was no nexus which was discernible, comma, between the requirement and scope of the tender. Full stop. Since the said ground was the determinant in the previous judgment of holding the criterion to be arbitrary, comma, in the absence of such criterion in the present case, comma, it cannot be said that the clause in question was arbitrary. Full stop. Next para. Insofar as the previous years of experience are concerned, comma, even in the said cited judgment, comma, the learned single judge affirmed the said clause in the tender. Full stop. That apart, comma, even independently of such judgment, comma, the time for which previous experience is sought by the employer is entirely within the domain of expertise of the tender issuing authority and the experts thereof. Full stop. It is entirely beyond the expertise of the courts of law to decide on such issue at all. Full stop. Next para. Hence, comma, insofar as the present impugned corrigendum is concerned, comma, the primacy of the tender issuing authority regarding the type of contractors and participants sought by the said employer for participation in the tender process to supply cooked diet to a cancer hospital has to be honored and respected. Full stop. Next para. Hence, comma, the challenge to the corrigendum fails on both the above scores. Full stop. Next para. Insofar as the allegation that the corrigendum has been floated in the 11th hour is concerned, comma, the same also does not hold water, comma, since sufficient participation time was available to the participants, comma, including the petitioner in the tender process even after the corrigendum. Full stop. In any event, comma, since the petitioner submits that it is not eligible in view of not having work experience for 5 years in a cancer hospital, comma, the said determinant is not relevant in the present context. Full stop. Next para. However, comma, insofar as the qualifications of the petitioner are concerned, comma, this court cannot enter into a conclusive finding as regards the same, comma, since it may very well be that the petitioner has had the requisite experience as sought in the corrigendum itself as well. Full stop. Be that as it may, comma, in view of the above observations, comma, the challenge to the corrigendum fails. Full stop. Insofar as the non-consideration of the representation of the petitioner is concerned, comma, the same is also quite late in the day, comma, since the specific stipulation in the notice inviting tender was that all doubts have to be creased out, CREAs, creased out in the pre-bid meeting itself. First up, having not done so, comma, at the behest of whoever, comma, the petitioner cannot be permitted to do so, comma, thereby having an edge, EDG, over the other competitors in that regard. Full stop, hence, comma, adhering to the tender conditions, comma, the said representation cannot be reopened at this juncture. Full stop, next para. However, comma, since learned counsel for the petitioner submits that the petitioner, comma, in the case of failure in the writ petition, comma, be given sufficient time to participate in the tender if otherwise eligible, comma, the last date for submitting the bids is deemed to be extended till July 10, 2023, full stop. The respondent authorities shall notify such altered last date of bid submission in their website by tomorrow. Full stop. Next para. However, comma, in view of the above observations, comma, the challenge in the writ petition fails. Accordingly, WPA number 15162 of 2023 is dismissed on contest without any order as to cost, comma, in the light of the direction given above to the respondent authorities. Thank you. Yep.
23.
My writ petition, my lord, in respect of a my lord, lookout circular, may I file the affidavit of service?
In respect of a
Lookout circular, my lord. My lord, the petitioner was a director of my lord.
Good service affected.
Good service affected. 1, 2, 1, 3, 4 has been affected. Respondent number 2 is my lord, door locked intimation, sir. Your lordship kindly sees my lord.
Whose door is locked?
5 also, my lord. The bank.
Minister of Home Affairs.
Yes. Who is my lord?
The bank is necessary.
Bank, sir. Bank, sir. Bank
Door
has been served. Door locks, my lord, Bureau of Immigration. 2 is my lord, Joint Secretary, Ministry of Home Affairs.
Door is always locked. Yes. What is the grievance?
My lord,
The bank has to answer
why this is my lord, actually
Yes,
because
is on-
I have
on the
not
basis
been, I have not been my lord, even given the my lord, lookout circular. I
Give
have
another
been
notice to
included.
the bank, please. I'll keep it at the top tomorrow, fairly at the top tomorrow, but they have to be heard. If they don't appear, choose to not to appear, then I'll have to set aside.
Very good.
Despite good service, comma, none appears for the respondent bank. First up, the other respondents are also not represented, comma, in spite of being served. Full stop. Next para. However, comma, since at least the respondent bank has to answer for the issuance of a lookout circular, comma, apparently at the behest of the respondent number 5 bank, comma, another opportunity is required to be given to the respondent number 5 to enter appearance and contest the writ petition. Full stop. Accordingly, the petitioner, the learned advocate on record for the petitioner is requested to serve a notice on his counterpart appearing for the respondent number 5 bank, indicating that the matter shall be listed fairly at the top of the list day after tomorrow.
Very good.
Full stop. A receipt in that regard shall be filed in court on the next returnable date. Full stop. It is made clear that in the event none appears for the respondents on the next returnable date as well, comma, the writ petition may be disposed of ex parte in the absence of the respondents.
Great.
Fairly at the top day after tomorrow. Thank you.
Upgraded matter item 24.
My lord, I am appearing for the petitioner.
Yes.
I am for the respondent number 456, my lord. My lord, learned on record is out of station.
All the upgraded matter, no time. Yes.
Please, my lord.
Others have been served. Other respondents have been served.
Yes, my lord.
What is the matter?
Already served and my lord, there was a direction passed by the Honorable Justice Moushumi Bhattacharya on 31st.
What is the urgency in the matter?
My lord, we have been cheated by the employee and the executive of the insurance company. We have challenged the order of the insurance ombudsman.
For the insurance company,
Yes, yes, my lord. For Tata.
it will retain its position in the upgraded list. I'll take it up tomorrow.
Tomorrow will be fine.
Very well. An adjournment is sought on behalf of the insurance company when the matter is called on for hearing, although the petitioners are represented through counsel. Full stop. Considering that there is urgency in the matter, the matter is adjourned till tomorrow and shall retain its position in the upgraded list. Thank you. আর একটু ঢুকলো তো আপগ্রেড লিস্টেড একই জায়গা থেকে মানে একই তো এক তো প্রথম থাকবে
Lordship, I am for the petitioner.
Yes, please, what is the matter?
Issue of this writ petition is Lordship, without disclosing all details of the nominee, the bank authority disbursed the amount, deposited amount lies in the account, saving account of the.
Yes, Mr. Shah, you said it was disbursed to the nominee.
Nominees, my lord.
Kindly-
And the petitioner is claiming to be the wife of the deceased, my lord, and, but she never recorded her name, or the deceased never recorded the name.
Yeah, you wanted to point out some other aspects in there.
Lordship, Lordship directed the bank authority. to
File a
dis-
civil suit against the nominee. Mr. Shah, please disclose the name.
Disclose everything.
Did not disclose, Lordship did not
Well,
disclose. Kindly suppress the fact, Lordship. For the reason I am actually lost my opportunity, Lordship.
Well, can you see paragraph 3 of my affidavit?
Lordship,
Paragraph
give me
3,
opportunity.
sorry, page
No,
3.
Yes, you have pointed
Page
out.
3, paragraph
Paragraph
F.
3 you have pointed out, Mr. Shah. Now take your seat. Yes, what about paragraph 3 first? Then continue.
Lordship, in respect of the saving account, Lordship directed.
They are paragraph 3 first.
Page 3, my lord. Page 3, paragraph F, G, H, I.
Names are
Lordship,
given.
Lordship, I am submitting, Lordship. Lordship directed bank authority to submit this, disclose the all details. Lordship, in respect of the saving account, bank authority did not disclose actual amount which is lies in the account of the deceased husband and which is subject matter of the nominee.
Need not.
Without giving any details, Lordship, without giving any details, only bank authority stated, kindly see, Lordship, subpara H and I, where the bank authority only stated, after death of the husband Somnath Mukherjee, respondent bank received a request from settlement of the claim in respect of the said account in question from the said father of the Somnath Mukherjee being nominee of the account. And I, Lordship, accordingly, respondent bank adjusted the sale loan from the same account. And respondent authority first time said that
Your
from the-
remedy lies before a civil court.
Lordship, if I cannot
You are
get-
claiming to be the wife of the deceased person.
but I cannot approach to the civic court because without giving details.
That's not their lookout.
Without giving details, Lordship, I
Take a proper advice. You know what to do. You get have the name of the nominees. You evaluate it at. I need not advise you on the civil suit. Evaluate it to the maximum. File a suit. Then it can be reduced also
Lordship, I have
the fees.
Lordship, I have a right over the.
Take leave from the court. You know what to do. File a civil suit with maximum thing. Court fees. You seek leave to put in later, and take information. You give inspection and discovery. They will the defendants will have to disclose. Give your interrogatories. They'll disclose the amounts lying there.
Lordship, but jurisdiction.
You know what to do.
Lordship,
File a civil suit. No.
But Lordship, kindly give me opportunity.
I've given you sufficient opportunity, Mr. Noskor. Don't say that.
Lordship.
This is the second day I'm giving you opportunity. Don't waste court's time.
Lordship, jurisdiction of the learned court depend upon the sealing of the amount of the property. If they did not disclose the amount of the actual amount, the petitioner face great difficulty. Lordship, petitioner fell in trap of order to rule to Lordship also.
After order record. Learned counsel for the petitioner contends that the petitioner was the wife of the deceased account holder with the respondent bank. First up, after the demise of the petitioner's husband, the respondent bank is withholding the amount lying in such accounts of the deceased husband. Full stop. Next para, learned counsel appearing for the respondent number 5 / State Bank of India submits that the bank has, comma, in its affidavit in opposition in the present writ petition, comma, clearly disclosed the names of the nominees of the account holder, comma, in whose no, to whom the requisite amounts lying in such accounts have been duly disbursed by the bank. Full stop. Next para. Learned counsel for the petitioner submits that the amounts lying in each of the said accounts have not been duly disclosed, comma, for which the petitioner is not able to file a regular civil suit before a competent civil court. Full stop. Next para. However, comma, the duty of the bank within the contemplation of a prudent person as envisaged in the Negotiable Instruments Act, comma, is to cater to the needs of its customers. Full stop. In the present case, comma, since the deceased account holder had clearly mentioned certain nominees to the account, comma, the bank duly discharged its liabilities in disbursing the amounts to the said nominees, comma, whose names have been amply clarified in the affidavit in opposition filed in connection with the present writ petition. Full stop. Next para. Insofar as the amounts lying respectively in the said accounts at the relevant points of time are concerned, comma, it is not the duty of the bank to furnish the said quanta to the petitioner, comma, since the petitioner was neither a nominee nor an account holder with the bank. Full stop. However, comma, it is open to the petitioner to file a civil suit, comma, on the usual presumptions of law and to seek interrogatories and discovery in such suit, comma, which advice need not be given by a court of law to the petitioner. Full stop. However, comma, it cannot be denied that the appropriate relief lies before the petitioner before a competent civil court, comma, where the petitioner has to claim her has to make her claim regarding the estate of the deceased, comma, including the monies in question, comma, full stop. Next para. Accordingly, WPA 27319 of 2022 is disposed of by granting liberty to the petitioner to approach the competent civil court, making due claims against the respondents herein as well as the nominees to the account of the deceased husband of the petitioner with the State Bank of India and other banks, comma, if any. Full stop. If such a suit is filed, comma, it will be open to the civil court to decide all issues therein independently and in accordance with law without being influenced in any manner by the observations made herein. Full stop. No address to cause urgent certificate. I'm sorry, Mr. Nashko. You take appropriate advice. What you have to do?
Lordship, only my prayer, Lordship.
Nothing is.
I
Call
have
on next.
another remedy, Lordship.
26.
Whatever remedy go there.
In item number 26, my lord, for the necessary private parties has not been implemented as party respondent.
But I'm for the
whose name will appear in the last annexure, my lord.
What is the dispute about?
No, my lord, what happened in this writ petition, my lord? Petitioner, if you are
so implead all whoever
is not required. It's my petition is not required. Now kindly go through the writ petition once.
Yes.
The petitioner, if your lordship is a society registered under Society Registration Act. My lord, subsequently, a scheme called river lifting irrigation. A scheme called river lifting irrigation has been given to the petitioner to run the scheme. The scheme was going on. Subsequently, some members of the society raised certain dispute between
You are the contractor. You are doing that work.
Yes, the society is doing that work.
Who are you?
I'm the society.
Acha, society itself. Very
Society itself. And now some member of the society raised certain dispute. Considering such dispute, what video done, that is the impugned order. Page 22. Video says, unless you allow all the person to be the member of the society or the executive committee, we will we will take steps so that you
show me that. Show me that.
Page 22.
All the persons means whoever objected.
Whoever objected. You have to make them an executive committee member. Otherwise, I will dissolve the society and I will take out the.
I am there. My names are there, my lord.
This
is also a perverse finding because বন্ধুত্বপূর্ণ পরিবেশে is stated there. It cannot be obvious.
30 জন অভিযোগের ভিত্তিতে নিম্ন স্বাক্ষরকারী টাকা 10/2/2005 তারিখে টেয়া শান্তি সুধা বিদ্যা মন্দির অধিবেশনে দায়িত্বপ্রাপ্ত আধিকারিক পরিবারকে পিছু একজনকে এক্সিকিউটিভ কমিটি পুনর্গঠন করার নির্দেশ প্রথম পক্ষদের দেওয়া হয়েছিল, কিন্তু আজ পর্যন্ত সেই কাজ তারা করছেন এরকম কোনো তথ্য পাওয়া যায় নাই। অন্যদিকে দ্বিতীয় পক্ষ 28/10/2022 তারিখে পেশ করা নতুন কমিটি ওই সমিতির গৃহীত মেমোরান্ডাম অনুযায়ী গণতান্ত্রিক পদ্ধতিতে গঠিত হয়েছে, এমন বিশ্বাসযোগ্য তথ্য পাওয়া গেল না। মতো পরিস্থিতিতে সাগরদিঘি বিধানসভা উপনির্বাচনের বিধিনিষেধ থাকার কারণে এবং চলতি বোরো মরশুমে নির্বিচ্ছিন্ন সেচ পরিষেবা বজায় রাখতে কাঁদি মহকুমার মাননীয় মহকুমা শাসক মহাশয় তাদের উপদেশে অনুযায়ী প্রথম পক্ষ ও দ্বিতীয় পক্ষদের মধ্যে বন্ধুত্বপূর্ণ পরিবেশে আগামী 8ই ফেব্রুয়ারি 2023 বেলা 3টের সময় নিম্ন স্বাক্ষরকারীকরণে এক্সিকিউটিভ কমিটি পুনর্গঠন ও তাদের মধ্যে অফিস বেয়ারার সঙ্গে আলোচনা করতে হবে। মানে দিস ইজ মাই কমিটি, দিস ইজ আ কমিটি আন্ডার দ্য
This is only restricted to this discussion. নিম্ন স্বাক্ষরকারী
পেনাল পজিশন। যদি এই প্রচেষ্টায় কোনো পক্ষ অসহযোগিতা করেন তবে এই প্রকল্পের পরিষেবা পুরোপুরি বন্ধ রাখার ব্যবস্থা নেওয়া হবে এবং সেই দায় আপত্তিকারী অবধি বর্তাবে। The authority who issued the letter, he is not the authority who issued the contract. But can you see who issued the contract? I have annexed the document. That is page 16. The assistant engineer of the irrigation department is the tender issuing authority. Can you see page 16?
Which respondent is this authority?
The block development officer.
BDO passed this order.
Yes, my lord.
সমষ্টি উন্নয়ন আধিকারিক.
Yes.
That is the Bengali of BDO.
BDO, block development officer.
Yes.
But he is not even the authority to issue the contract.
Let me see how the state defends. Yes, sir.
I have no instructions, my lord. Your lordship.
You have no defense to that.
Some defense is there, my lord.
What?
They want to say that they were working very well, the erstwhile committee. Automatically, they won't want that.
What is this? Can the BDO direct them to include them in executive committee?
So,
Yes, Mr. Mukherjee, nothing.
Second,
They are not necessary parties.
they are now the executive of the committee, my lord, members. They are not.
They are executive of the executive committee members.
They have not annexed all the documents, my lord.
they're not annexed.
8 February documents is very much necessary.
Pardon?
8 February document is very much necessary when our names are there.
Can the BDO say this?
But this is
If you are already members of the executive committee, then what is the need of this direction?
We are the members of the new committee, my lord.
Mr. Mukherjee, please come to the microphone.
We are the members of the new committee, my lord. I have no, if I can.
This new committee was formed after 2nd of February.
By the BDO.
After second of
By the BDO.
How were they formed? How were they implemented?
By in a democratic way, my lord. By election,
You can elect it.
Mr.
As
Ghosh,
well-
don't comment. Make a
I'm
please take your seat. Yes. How?
But
What is the democratic process, Mr.
from every family?
There should be one.
There should be one member. But over here only a particular family has been, they are the petitioners, my lord. Father, mother and son, they are the petitioners. Other members are not.
Mr. Mukherjee, I'll stay the operation of this file affidavits.
But let them implement them as party and they are not.
You are not parties here.
No, that is my difficulty, my lord. Let them implement, but the second,
You are appearing for whom?
this, I have got the Vakaratnama. I can appear on Vishnu Hajra in page 22. Vishnu Hajra, second Pokko, Dityo Pokko.
No, you are not a respondent here.
They have not been, we have not been implemented as party
How did you
respondent.
know about the writ petition? After seeing on the list, you are coming.
No, my lord.
Copy was served on whom? Whose copy are you carrying?
Nothing has been solved. I obtained it from Sarthak, my lord. I candidly on Sarthak, website Sarthak. I candidly submit.
When was the new committee formed?
No copy has been served, my lord. I came to know and am appearing before my lord. Let them implement.
Mr. Mukherjee, I'm telling you this.
Yes.
If you are the members of new executive committee,
Yes, new everything
order
already.
does not affect you.
Thank you.
But
After the
if-
filing of this
But I mean, what is this? BDO doesn't have jurisdiction to do this.
No, my lord, a complaint has been taken up by both the.
If you have been elected in due process of law, then you will function as executive. Nothing prevents you. You are not parties yet. This does not bind you also. Learned counsel for the petitioner at order. Learned counsel for the petitioner contends that the block development officer concerned, by the impugned order dated February 2, 2023, acted dehors his authority as well as law in observing that all the objectors to the petitioner society's work would have to be implemented as executive committee members and office bearers. Full stop. It is submitted that, comma, in the said order, comma, written in Bengali vernacular, comma, it has also been stated that if any party does not cooperate with the said endeavor of the BDO, comma, the entire project would be stopped. Full stop. Next para. It is seen from the materials on record that the petitioner's society is a duly registered society under the West Bengal Societies Registration Act 1961. Full stop. The same is constituted of cultivators of the area. Full stop. Next para. Insofar as the impugned order is concerned, comma, the same is palpably dehors the authority of the BDO. Full stop. Next para. At this juncture, comma, it is submitted by Mr. you write Mukhopadhyay, by Mr. Mukhopadhyay, learned counsel having instruction to appear along with his learned advocate on record on behalf of the objectors, comma, who were directed to be impleaded as executive committee members by the impugned order, comma, that the said members are necessary parties to the present writ petition. Full stop. It is submitted that, comma, subsequently, comma, the said objectors have been impleaded as executive committee members of the petitioner's society and, comma, thus, comma, are necessary parties to the writ petition. Full stop. Next para. However, comma, even if the respondent, even if the clients of Mr. Mukhopadhyay plead that they are duly elected executive committee members of the society, comma, they cannot be aggrieved by the outcome of the present writ petition. Full stop. The purview of challenge of the present writ petition is the direction by the BDO to incorporate certain outsiders as executive committee members upon a reconstitution of the executive committee as well as the office bearers. Full stop. The said prerogative lies entirely with the society, comma, in terms of the memorandum and articles of association of the said society. Full stop. Moreover, comma, the block development officer has no authority or jurisdiction in law to give any such direction and, comma, in default of compliance of the same, comma, to stop a project which is legally being undertaken by the registered society. Full stop. Next para. Hence, comma, whoever may be affected by the outcome of the present writ petition, comma, duly elected executive committee members cannot fall within the purview of such persons. Full stop. Next para. However, comma, insofar as the impugned exercise of authority is concerned, comma, the same is palpably unlawful and has to be struck down. Full stop. Accordingly, WPA 3540 of 2023 is allowed, comma, thereby setting aside the decision taken by the block development officer concerned, that is respondent number 8 herein, comma, on February 2, 2023, within bracket annexure P4 at page 22 of the present writ petition, bracket closed. Any consequential action taken pursuant thereto is accordingly set aside as well. Full stop. However, comma, it is made clear that no person who is not a party to the writ petition shall be precluded from claiming any rights, comma, if accrued in their favor, otherwise in accordance with law. No rights to cause urgent certificate.
But I'm extremely
If in
sorry.
accordance with law, Mr. Mukhopadhyay, you will get your rights.
No, but this is only a notice. They are challenging only a notice, but subsequent.
There is a clause there, default clause.
No, default clause is there, my lord. It's only a notice or subsequent.
But I'm extremely sorry for disturbing.
27.
At the time-
For what?
At the time of when my lord was
No.
Now you are sorry because your application has been allowed.
No. That's that.
I don't accept it.
I was
Whether
interrupted.
whether my lord, they are implemented as parties or no, not yet. Because I have
No, cannot be implemented. কোথাটা বলেছে? You have not made any formal application and need not
no,
reject
I
your
did not.
application.
I did not.
I have said that you are not necessary party somewhere.
No, not necessary party বলেছেন তো sir.
27.
Yes. Yes.
Lordship, I am for the petition. My lord, I am appearing on behalf of respondent number 2. Lordship, I am filing.
Who is
here-
the main contesting respondent?
My lord, both. However,
Good service on one.
good service, my lord. And my lord, they are aware of this fact because after serving the writ petition, my lord, they had conducted the hearing. And they even said in the hearing that everything depends on the outcome of the writ petition of what has been filed.
No. If they said that, I'll direct affidavits.
My lord,
Depends on the
but it's a
outcome.
very short point involved, my lord.
Yes, what is the point?
My lord, I have a land and that was acquired by the railways for dedicated freight corridors. My lord, compensation was granted. I was being termed as an interested person. My lord, the amount has been credited in my account.
Yes.
My lord, when I go to withdraw the amount, account has been freezed for no reasons. Then, my lord, I issue a letter to them, no reply. Thereafter, my lord, I file a civil suit because I had the knowledge that if I don't file a civil suit or obtain an order of injunction, they might remit back the amount of what is being in my credit. My lord, then I write a letter to them. They don't reply, and when I serve the order of the
The
injunction,
strategy you're for the bank.
my lord, manager, not for the bank. I'm not an impanel lawyer, my lords, but my lord, I'm appearing for manager of the bank.
You're being reclassed. Yes, anyway, please
Lord,
continue.
Then at page 38, my lord, for the first time bank replies, that is a letter dated 30th of September 2022, my lord.
Yes.
When I've served them the order of the injunction. My lord, in the third paragraph, apart from that, the government of West Bengal through a department, Paschim Bardhaman, by a letter dated 25th of August 2022, by the memo number, directed this bank to block, freeze the account number so and so stands in your name,
State is a necessary party then.
so that the amount to refund.
If the government of West Bengal has said so, they are a necessary party.
But
At
they
their
are.
case, this is-
They are, my lord.
With them, give a copy, come back day after.
My lord, already served long back. And my
Are
lord,
the
this-
parties here?
Yes, my lord, number 1.
Number 1 is office of the district magistrate and collector.
My lord, but this particular thing was acquired by them only.
No. Here in this communication, they say, apart from that, the government of West Bengal through a department of Paschim Bardhaman by a letter has said something, directed the bank to block. So they are acting at the behest of the government.
Yes, my lord, but they are referring to the office of the DM, my lord. If your lordship kindly takes page 19 of my writ petition, my lord.
No, page 30, the one you read.
My lord, that is
In the second paragraph, they have referred to the government's direction.
My lord, that is the larger.
No,
one they are
please
writing.
implead the state government also. They may have something to say.
If your lordship kindly takes page 19 once.
Page 19, yes.
My lord, government of West Bengal, they mean office of the DM and collector.
Acha,
This, my lord. And
some office at Puru Paschim Bardhaman means this.
this. And my lord, the same is at page
All right, get your
20
point.
as well. And my lord, they are being added as respondent number 1 herein.
Have they given any ground, solid ground apart
No
from
grounds,
this?
no grounds,
Yes, why are
nothing.
you,
My lord,
nothing?
we have only received the instruction. What happened, my lord, in this case? The present petitioner came at our bank on June 2022 and said a huge amount of money he wants to deposit. Sorry, that will come into his account. The amount will come into his account. The respondent number 2, being the manager Axis Bank, he replied that if KYC, etc., are in proper form, then any amount come and can be deposited in his account. 3 days after, the land acquisition department sent one email saying that the said amount entered into the petitioner's account as a result of dispute, and the manager should not release the amount and account should be freezed.
So please implead the state as a party.
And
Learned
my lord,
counsel for the
civil
petitioner,
suit
no, I'll
also
direct him
pending.
to implead and come back day after tomorrow or day after that. Just serve on the government petitioner's office.
My lord, but however, my lord, they have credited the exact amount through NACH transaction, which is at page 25, my lord. They have not credited or debited even
Learned
1
counsel
rupee
for
less.
the petitioner contends that due to apparently due to a communication of the district magistrate, Paschim Bardhaman's office, the respondent number 2 bank has frozen an account containing the compensation accrued to the petitioner in view of an acquisition of land by the government. Full stop, next para. Although learned counsel for the petitioner places reliance on page 19 to indicate that the freezing was done at the behest of the office of the district magistrate, Paschim Bardhaman, in the letter dated September 30, 2022, annexed at page 38 of the writ petition, a communication by a department of the government of West Bengal by a letter dated August 25, 2022 has also been referred to, as one of the reasons for blocking the account of the petitioner. Next para, hence, in order to have a complete adjudication of the matter, the petitioner shall implead the state of West Bengal as a party respondent to the present writ petition. The necessary consequential amendment to the cause title of the writ petition in that regard shall be made by the learned advocate on record for the petitioner during the course of the day. A copy shall be served on the added respondent, directly or through the office of the learned government pleader by tomorrow. And if a copy of the receipt in that regard shall be filed on the next date of hearing. The matter shall next be listed fairly at the top of the list under the same heading on July, day after tomorrow or day after that?
Day after tomorrow.
On July 5, 2023. 5th July, day after tomorrow.
Day after that is possible, I think.
That would be easier for you. তাহলে day after tomorrow, July 5 না করে July 6th করে দাও। July 6th, then not a receipt, affidavit of service করে দাও। Then make a affirmation affidavit of service.
Grateful, man.
Great, come. দুটোই কিছু ফিক্সড আছে?
Yes,
My lord, may I have your lordship's kind leave to mention, my lord, upon notice? What? My lord, the urgency is, my lord, there has been a lookout circular issued in my name. The lookout circular was issued prior also, but there was an interim order, so my lord, I was allowed to travel. That interim
Where did you mention in the morning?
my lord, I couldn't, my
No.
lord, miss the.
Not at this hour. Call
My
on
lord,
list.
the only urgency is, my lord, that
28.
great.
I am for the petitioner, my lord.
Yes.
My lord, this is a case of, my lord, petitioner prayed for remission of his life sentence. My lord, petitioner undergone sentence, my lord, 30 plus years. 30 plus years. This is the, my lord, fourth round of litigation, my lord. My lord, kindly see, my lord, the last sentence review board held meeting in view of the order of Justice Bhattacharya, M. Bhattacharya, my lord. And my lord, in that, my lord, page 48, my lord, kindly see, my lord, the ingredient which to be considered for release of a lifer, that was not considered. As it was held by Honorable Justice M. Bhattacharya in page 44 in its earlier judgment. My lord, kindly have a look page 44 first. Well, middle portion, 2, 4, 6, 8, 10 line from top. The rejection does not clarify the particulars of the objection received by the board. Hence, the board is directed to take into account the conduct of the petitioner number 1 during his time in parole, as well as recent decision of the High Court and Supreme Court with regard to premature release of life convict for offense which are equally heinous, if not more than that in the present case. The board is directed to take decision on the petition number 1 in its next meeting within 6 weeks. That is by 31st January 2023. My lord, within this stipulated time, no meeting held, causing the petitioner to file another writ application. And while that writ application was pending, my lord, at that point of time, they come with this decision, my lord. And my lord, page 48, my lord, say the reason, my lord, though there is one another co-accused, my lord, Pandalal.
Yes. I appear for the respondent number 3, the Registrar General of this Honorable Court.
My lord, Pandalal. My lord, because of the fact there is a condition that the convicting court, the sentence of conviction passed by which court, that is the Tada court Diden. Now, since Tada court is nowhere, for that reason, Registrar General will answer or pass its valuable opinion.
Very well. Mr. Banerjee, please take your seat. I'll just hear Mr.
My lord,
Yes.
kindly see page 48, my lord. It starts from 47.
Mhm.
This is the sentence board, my lord, meeting, my lord. Page 48. The case of life convict Muhammad Khalid, son of late Ijarul Haq of Midnapur Central Correctional Home, was placed for reconsideration as per directive of Honorable High Court at Calcutta in WPA number such and such on 29/11/2022. The petitioner has undergone more than 29 years of imprisonment, having been convicted in Tada case number 1 of 1993 arising out of Bowbajar PS case number 84 dated 17 March 1993 under section 120B, section 5 ES Act and section 321 of the Tada Act such and such, section 34 of IPC such and such Act. Earlier in its 65th meeting held on 24th July 2021, State Sentence Review Board had recommended for premature release of life convict Muhammad Khalid in earlier meeting. Even though Kolkata police authorities had strong objection against his premature release, however, the 65th meeting of the State Sentence Review Board held on 14th July 2021, case of 126 life convict were recommended to the government. The state government approved 61 male convict and 2 female convict for premature release. Among the SSRB recommended cases to be forwarded to the convicting court through the judicial department, case of the life convict Muhammad Khalid, the present petitioner, son of later, was not approved by the state government for consideration of the convicting court. As for the consideration of the convicting court, as he had committed a heinous crime involving bomb blast in crowded area in Kolkata that resulted death of 70 innocent people. My lord, this thing, my lord, need not to be considered, my lord, while, my lord, the releasing premature
It's
release.
practically a repeat of the previous.
My lord, and this time in view of the order of Justice Bhattacharya, my lord, that was not taken into consideration.
Current conduct during parole, during
The conduct is fine, my lord. He was all along, my lord. I have furnished my lord.
Justice Bhattacharya stipulated that the
Yes.
conduct of the petitioner
That
during his
was not
parole,
mentioned.
not
That was
only
not taken
conduct, not only conduct during his parole, but the
Yes.
Supreme Court has time and
Yes,
held
yes.
conduct in custody also.
Yes. I have no advantage. I lost my potentiality. I have a academic.
Potentiality commit a crime.
No. I have lost my
Potentiality you have lost.
potentiality to commit further crime
Say that.
because I am 58 now, my lord. My lord, I have a family business, my lord. I have, my lord.
Family business of making bombs.
No, my lord. This is at the young age, my lord.
In the Bowazar bomb blast.
It is, my lord, at the young age, misguided by some, my lord, some antisocial element, my lord. My lord,
We are not sitting in judgment over that. You have already served your sentence.
Yes.
But
30
you are serving your sentence.
30 plus, my lord. Kindly see how long I on parole, my lord, and no, my lord, adverse report, my lord.
But
And, my lord, similarly,
Mr. Poddar, can you please show me the previous adverse reports given by the police? Why it was refused?
no, nothing.
You have not annexed anything.
Only mention here. Only mention here. My lord, kindly see annexed PU1, my lord. I detail the parole period, my lord. My lord, kindly first starts, my lord, 15th June 2012, 5 days. It is after, my lord, after serving 14 years. Parole starts.
Poddar, have you shown anything to show any certificate or anything of sorts to show that his conduct was good?
Yes.
Show me that.
Here. It is a jailer certificate.
Yes, I want to see that once.
Yes.
Have you brought any of the Supreme Courts, Mr. Poddar?
Yes. I have annexed, my lord, Rajiv Gandhi's.
Rajiv Gandhi?
My lord,
Rajiv Gandhi's parole?
No. In Rajiv Gandhi's murder case, my lord,
Yes.
the lifer has been released, my lord, prematurely, my lord, that I annexed, my lord. My lord,
Why didn't you annex this to the writ petition, Mr. Poddar? You should have annexed this to the writ petition.
It was, my
This
lord,
is not
public.
public.
It was given me later on, my lord. If your lordship so desire, my lord, I can file it by supplementary affidavit, my lord.
Even now, at the present moment, I can direct another demand to the SSRB if you are satisfied with that. But that will go on forever and ever.
Yes. The 30 years I have served, my lord.
Mr. Poddar, if you want a if you want an
I have
effective
also-
order, then
I have
just
also relied on your lordship's judgment, my lord.
not my judgment, Supreme Court judgments. Please
Yes,
rely on
yes,
any of
yes.
the Supreme Court
Yes.
judgments and put this on record. By you have a supplementary, give another notice. Come back how soon can you file that supplementary affidavit? Annexing this document, whatever is relevant, annex there.
My lord, Monday.
No, there's one thing.
Yes, Mr.
Page 13 is the affidavit. He's a lifer undergoing a sentence in a correctional home. He is before the commissioner.
Yes, while he was in parole. Last parole. My lord, kindly see, I have written it at tenor of the last parole, my lord.
What was the period of last parole?
Yes, 1 month. My lord, from page 15, from 20th May 2021 to 20th May 2021 to 5th August 28. No, it is in earlier years. My last parole, my lord, it is within that period, my lord, it was made, my lord. Last parole, the time double. Last parole period there. July 23, June 23, my lord, due to Ramjan, my lord. For 1 month, it was he was on parole.
This was affirmed on 11th of April.
Date of short leave parole was the 3rd of April.
1 month. Ramjan period, he was in
3rd of
parole.
April,
Yes.
page 17.
Yes.
Yes, you were on. He was on parole. Page 17 is very clear on that. Learned counsel for the petitioner argues that, in contravention of a previous direction, dated November 29, 2022, passed in WPA 23255 of 2019 of a coordinate bench, comma, the SSRB, that is the State Sentence Review Board, has failed to take into consideration the conduct of the petitioner during his time in parole and other relevant considerations when reiterating their objection to premature release of the petitioner, comma, who has already served about 30 years of his sentence, comma, having been convicted in the Bowbazar bomb blasts case. First up, next para. Learned Counsel places certain portions of the impugned decision of the SSRB dated February 17, 2023 in support of his contentions. First up, since the petitioner seeks to place reliance on certain further documents, comma, in support of his contention that the petitioner has all along been showing good conduct during custody and during the times of parole, comma, the petitioner is granted leave to file a supplementary affidavit, annexing all relevant documents. First of such affidavit shall be filed on July 10, 2023, when the matter shall be listed fairly at the top of the list. First up, the petitioner shall serve an advance copy of the said supplementary affidavit and also give a notice to the state respondent indicating the next returnable date. First, please come back on that date. Let us see.
On Monday, it will appear in the list.
When it will be listed fairly at the top, I said.
Deeply obliged.
Yes.
29.
Captive power,
Lord,
or free power.
no, this is not relating to power. Thankfully.
What is this?
Now, my Lord,
Thankfully. Yes.
no, my Lord, this relates to, my Lord, the matter is very short. My Lord, because of the, my Lord, non-availability of the bench before the DRT3, my Lord, I'm before your Lordship. My Lord, I was inducted as a tenant on December 2017.
Bench has come in the meantime.
Yes, my Lord, DRT3 is functioning now.
Go there, Liberty.
That is my instruction.
Be sure on your instruction. Otherwise, it
My Lord,
will
I have
You'll
taken
have to recall
instruction.
the
on
order.
I have taken instruction on that. It is now functioning. Only one prayer, my Lord, for a short while, if the auction can be stayed, or my Lord,
when is the auction?
Auction was fixed on 29th. Lord, and if the auction has taken place, my Lord, then in that case, my Lord,
You will await by the result of what? Today's order. Can I do that?
for the time being, my Lord, 7 days or 10 days.
What is the English of Abdar? Exact English, there is no exact English, probably. Because Englishmen don't Abdar. No, Mr. Kankar. Learned Counsel for the petitioner seeks to move this court on the ground of urgency, comma, due to non-availability of the appropriate tribunal at the time of filing the writ petition. First up, however, comma, Learned Counsel appearing for the respondents submits that you are for respondent numbers 2 and 3.
2 and 3.
Respondent numbers 2 and 3 submits that in the meantime, comma, a presiding officer has been appointed as and is functioning in the concerned bench of the tribunal, that is the DRT3 Kolkata. First up, in such view of the matter, comma, WPA 11463 of 2023 is disposed of with liberty to the petitioner to file an appropriate application, challenge.
Already pending. It's already pending.
To file, to move the identical challenge initiated by the petitioner before the said tribunal and to raise all disputes as sought to be raised in the present writ petition before the said forum. First up, it is made clear that the merits of the disputes have not been gone into by this court at all.
Not only a direction so that it can be expeditiously taken up, Lord. If that can be, Lord.
It is expected that the tribunal shall, comma, when so approached by the petitioner, comma, make endeavor to decide the petitioner's matter expeditiously. Grateful. Thank you.
30.
Yes.
If it pleases your lordship, I beg to appear for the petitioner, my lord.
Right.
My lord, before my learned friend start, I must, my lord, say
Get
one
started
thing.
already.
No, my lord. The entire issue has already, my lord, pending before the district magistrate. District magistrate has already, my lord, taken out the matter. Hearing was taken place. All the parties are represented. Now, my lord, this is award for order or judgment. This is the crux of the matter.
Page 132, my lord.
In my respectful submission, my lord, this is repetition only to create pressure. The person who has affirmed this repetition, he first moved for individual capacity, but my lord was generous enough. My lord directed relief to the realm. All the persons who are active, my lord was pleased to give them relief. Thereafter, the society, Gulaga, they moved. My lord passed the order that yes, whoever approaches, they will get electricity. Now this is the third time, same prayer, everything is same.
My
And
lord,
the
this is
district magistrate is season of the matter, my lord.
My lord, this is the fifth round of litigation, my lord. Initially, lordships was approached by the petitioner, I mean the secretary of the petitioner society, my lord, in his individual capacity. Lordship may kindly take up your lordship's order, my lord, at page 32, my lord. Relevant will be page.
What about the matter being pending before the district magistrate?
My lord, that answer will that will be answered by page 132.
Private respondents are raising
132.
objection. We are trying to effect connection. They are raising objection.
The first you are placing some other page 32.
Yes, if your lordship may take the page 32, lordship.
Yes.
The relevant will be internal page 2, page 33, running page 33, the second paragraph, my lord. May I place it, my lord?
Please.
Learned counsel appearing for the private respondent number 9, who is incidentally is also the private respondent number 9 in this case, my lord, submits that initially respondent number 9 was the owner of the entire area. Subsequently, a portion of the area was sold out piecemeal to several vendors, who have subsequently formed an association by the name of such and such, who is the petitioner before your lordship in this case, my lord, which is a registered association. For the convenience of all the vendors, respondent number 9 has taken up the liability on itself to provide electric connection to all. That was their submission before your lordship. Now, in view of that, your lordships observed at page 34, the next page, my lord, the last paragraph, my lord, keeping in view such end, learned counsel for the petitioner is granted liberty to file a composite but brief supplementary affidavit on the next occasion, indicating the support of the society, Samiti, as well as its members in the WBSCDCL, giving such individual connection to each of the vendors. So, as it was pointed out by my learned friend, my lord, that although the petitioner approached your lordship in his individual capacity, but lordship was kind enough, my lord, to allow all the applicant, my lord, to get implemented through the supplementary affidavit, which was complied upon, my lord. And based on that, your lordship was pleased to pass final judgment and order, my lord, which starts at page 36. Relevant portions will be, my lord. Operative part starts at internal page 5, running page 40, my lord. The second last paragraph, my lord, or the third paragraph from the top, my lord. Hence, WPS such and such is disposed of by directing the distribution licensee to immediately make the necessary installation and raise the structure necessary for giving electricity connection individually to the petitioner and or other applicants. So, my lord, made it very categorical that the order will be applicable not only to the petitioner who approach your lordship in his individual capacity, but also in terms of the supplementary affidavit to all the applicants. This order, my lord, was never challenged by respondent number 9. However, my lord, an appeal was carried from this order, my lord, by a third party, my lord, who said, my lord, that his right has been prejudiced. That your lordship will find, my lord, that appeal, my lord, was finally disposed of by the Honorable Division Bench, my lord, by a judgment and order dated 30th June 2022. Lordship would find that, my lord, at page 106. Relevant portion will be, my lord, internal page 3, page 108, my lord.
108, yes.
My lord, may I place it, my lord? The last paragraph. In the said background, learned single judge has not committed any error in issuing a direction to the distribution licensee to take necessary steps for installation and raising the structure necessary for giving electricity connection individually to the respondent number 1 and other applicants. So, my lord, the Honorable Division Bench also recognized the rights of the other applicants, my lord. Now, my lord, the important portion will be, my lord, if 3 lines below that, my lord, if there is any objection by the appellant, so, my lord, your lordship's order was carried in appeal by this appellant, and this Honorable Division Bench
by
was
this appellant means
a third party,
by
my
the
lord.
third party,
My lord, and the Honorable Division Bench, my lord, was pleased, my lord, to restrict the objection to the appellant. So, my lord, if I place it, my lord, if there is any objection by the appellant in that process, then the steps which are required under rules such and such are to be taken, my lord. So, your lordship's order was modified to this extent only for the appellant and none others, my lord. That being the case, my lord.
But the objection, right of objection of the others cannot be stulted by the court.
But since lordship, respondent number 9 was before your lordship, in that 20,
Anybody and everybody can object to that.
the reason why your lordship did not entertain the objection was 3 reasons, my lord. It was not in air that your lordship passed that order, my lord. Lordship took three things into consideration. Number one, they were the initial owners who sold the land with income with the
Respondent number 9's rights were in this context were discussed.
Was discussed, my lord. Respondent number 9 said, my lord, they were the owners. They sold the land. After selling the land, how can they object? Number one. Number two, they were selling electricity illegally to these vendors at 3 times the rate. So all these things were considered, my lord, and thereafter their rights were their objections were discarded by your lordship, my lord. So that being the case, my lord.
So what happened after this?
After that, my lord,
somebody else raised an objection.
No, they themselves. Now I will tell you, 9 only. I'll tell you, lordship, my lord. Thereafter, my lord, there was an interim order to provide interim connection, my lord, in the by the division bench, my lord, in that appeal. We wanted that similar, my lord, facility extended, my lord. We approached your lordship. In this case, my lord, the association approached your lordship, my lord. That and your lordship was pleased to pass an order which starts at, my lord, running page 115, my lord.
Yes, 150.
My lord, the relevant portion will be, my lord, page 122, internal page 8, my lord.
Right.
It is expected, my lord, may I place it, my lord, second paragraph. It is expected that the necessary infrastructure required for giving independent electric connection to the people in the locality in question shall be developed by the distribution licensee as expeditiously as possible, of course, in accordance with law, my lord. So lordship passed this order, and lordship was also kind enough, my lord, to direct them to explore the possibility of giving temporary connection, which they, my lord, refused by a letter dated, my lord, 29 September 20.
They did not have the infrastructure also.
Of course, my lord. That starts at page 124, my lord. Relevant will be, my lord, page 126, the last portion, my lord, last paragraph. May I place it, my lord? As per the observation made in MAT so-and-so with can so-and-so and so-and-so, as well as WPA 20440, this was the application made by the society, my lord, in which your lordships directed them to give all, just to clarify, my lord, give connection to everybody in that society, members of the society who have applied, my lord. As per so-and-so, an application as per rule 3 of the works of license rule 2006 has been made before DM. So they say, my lord, as per your lordship's direction, they have referred it to the DM. So this was done, my lord, that was referred to the DM as per them. On kindly mark the date, my lord, on 29 September 2022, they say, my lord, that as per your lordship's direction and order, they have referred it to the DM, my lord. Accordingly, my lord, lordship would find DM passed an order. That order lordship would find at page 132. This was my reply, my lord, to their question that what about the matter pending before the district magistrate, my lord. Page 132, my lord, DM passed an order dated 22nd of November 2022. So the reference was on September, and on November, the DM passed an order. In this order, my lord, DM determined the compensation amount and allowed the work to be carried out.
Compensation given to whom? 9?
To know, my lord, the third party objector, my lord.
Yes, very well.
And the work was supposed to resume. It resumed, my lord. But what this third party objector did, my lord, instead of preferring an appeal, if he was aggrieved with that order, my lord, in terms of rule 3, my lord, he approached your lordship by filing a writ petition, my lord. And the WB, the distribution licensee, my lord, on the pretext of the pendency of the writ petition, denied to, my lord, advance with the work. Now your lordship will see, my lord.
The third party sought a modification order from me.
Yes, my lord. Challenging the DM's
fresh writ petition.
Fresh writ petition, my lord.
What happened there?
My lord, kindly just give me a moment, my lord.
Yes.
Lordship would find at page 167, my lord, the order passed in the writ petition, my lord.
Yes.
Now, my lord, they said that they have not attached necessary parties and all that. My lord, we appeared before your lordship, my lord, and we requested, my lord, that, my lord, due to the pendency of this writ petition, my lord, electricity connection has not been affected. So your lordship clarified, my lord, on the last page, internal page 2, running page 168, the last portion, my lord. It is made clear that no interim order has been passed at this stage, since the matter has not been heard even on prima facie merits. However, the mere pendency of the writ petition shall not come in the way of the distribution licensee giving electricity connection to any person. Now, my lord, when this happened, my lord, what they did, This your lordship passed on 9th of January, my lord. 9th of January 2023, my lord. Immediately on, my lord, 11th of January, lordship kindly sees the page 169, my lord, annexure P20. They considered the objections of the respondent number 9, my lord, and referred the matter again to DM, my lord.
By now, I have forgotten the chronology.
My lord, I will assist your lordship in.
Please do that.
My lord.
Because what happened immediately prior to this, I mean, the 2 steps prior to this, the objection was, third party's objection was referred to the magistrate.
Magistrate, my lord.
An order was passed on that.
Order
That
was-
was carried out, an appeal, a challenge was carried out.
Before this honorable court, my lord, before your lordship, my
Writ
lord.
petition is still pending. That
No, it is dismissed for default, my lord.
they will dismiss for default. In the meantime, this order was passed.
Yes, my lord.
They made another reference.
Another reference to TM, my lord. Now, this time they say, my lord, respondent number 9, whose initial objection was discarded by your lordship. They never preferred an appeal from your lordship's order, my lord. They accepted your lordship's appeal. Now they're again objecting, my lord. And they are the most,
what are challenged here?
my lord, we are seeking connection. Number 1, we are seeking compensation because of this delayed, and we have sought, my lord, if there is a, because one more thing, my lord, may I point out before your lordship, my lord, in the letter denying us temporary connection, they say, my lord, the distribution licensee says, my lord, that there is an internal line through which the respondent number 9 is giving connection to individual. We don't have a control over that internal line, and therefore we cannot do anything about it. So we wrote a legal notice to them. My lord, paragraph F.
Yes.
My lord, paragraph 3F in a bit, my lord, kindly, since I have said the contents of it in brief, my lord, as mentioned in paragraph 3F of your letter, the truck terminal limited, which is respondent number 9, my lord, is a bulk consumer of the WB SCDCL, over which the undersigned, my lord, he is the divisional engineer and station manager, says, my lord, on which the undersigned doesn't have any jurisdiction and is above the pay grade of him, my lord, to lodge an FIR, my lord, for illegal. He says that he doesn't have any jurisdiction, is pay grade of him, my lord. Unheard of, my lord.
What does he mean by this? Respondent number 9
That
pays
can-
less to him than the other officers.
That will, my lord, senior friend will explain before your lordship, my lord. But what I understood is this.
Probably that way.
No, my lord, who have taken.
What is about this pay grade?
The English may not be, my lord.
English.
But, my lord, I
Pay
get your
grade,
lordship.
somebody is saying pay grade, he doesn't know English.
It's wrong. What has happened, my lord? Say bulk connection consumers. Suppose like, my lord, the shopping mall. One connection will be
Give
there.
me a report,
and they will-
Mr. Kohli, give me a report as to what have you done with regard to this
No, I clear
illegal supply of electricity.
No, not illegal supply. I clear to your lordships. My learned friend says, my lord, the again reference to the district magistrate is not,
Yes.
is not the real fact. What has happened? Pursuant to lordship's direction in earlier writ petition, we have complied. We have given connection, all the consumers, whoever there. Now, subsequently, by taking.
You have given the connection.
Yes, by taking advantage of your lordship that others, now after completion of that connections, others consumers are coming into the play. And we are trying to effect connections. Now at this point, respondent number 9 is raising objection. We are to install 11 ports. They say this passage sought to be install the pole, it is belongs to me. We have raised objection. We don't allow him to install pole. Now, again, the matter has been referred to the district magistrate, and district magistrate hear out the matter. This is the second time, not the first. My learned friend is trying to all assemble together. That was complied with.
So every time somebody will apply for electricity, they
What can be done? He says it is my land. I will not allow.
Anyway, let me complete, Mr. Chattopadhyay. I'll come to you after that.
Just to clarify, my lord, what my learned senior friend has said, my lord, I think, my lord, he has been quite misguided by his client, my lord. If your lordship takes up, my lord, the list of applicants I have provided in my writ petition, my lord, page number 43, my lord. If my learned senior friend can satisfy your lordship that all 68 connections, my lord, have been provided, I am out of the court with cost, my lord.
No, not
I don't
68. I am not saying 68. I am
My lord,
saying
this is the list of applicants that was annexed along with the supplementary affidavit, along with the writ petition which was filed by the society. if my learned senior friend is with the instruction that they have provided us connection.
I am not
trace
saying
connection
my
of the-
largest friends, Paras Milot, is not, and I am saying, Milot, initially we are installed 10 poles. We are able to install 10 poles and we have given connection up to that extent. Now, Milot, another 11 poles are to be required to be installed for the purpose of effecting connection to these consumers. Now, when we are, Milot, taking steps, the respondent number 9 raising objection that we are not allowed to install the pole. That is why, Milord, the again matter, that portion has been referred to the district magistrate, and district magistrate, as per rule, your lordship knows, and district magistrate has already heard out the matters with all the, including my learned friends clients also present. And Milord, now, my instruction is, now we are yet to
My lord, there is
get
a
the order
syndicate.
from the district
There
magistrate.
is a
Even
syndicate, my
inspections
lord.
also.
If your lordship.
Why are you not giving the connection? Because it is pending before the district magistrate.
No. They are not allowing us to install pole. We have to
Yes,
install.
now that is pending before the district magistrate. They have taken out what is pending before the district magistrate.
So far, 11 poles is concerned. Rest of the poles.
That is what I am asking you, Mr.
Yes.
Kolle, that has been referred to district magistrate.
Yes, and that district magistrate has already, Milord, taken hearing all the parties. All parties are before there. Now we are yet to, Milord, the order from the district magistrate.
Yes, every time Mr. Chattopadhyay, I'll come back to you. Let me hear the respondent.
Perhaps the petitioner has failed to give the clear picture.
Nobody is giving me the clear picture. I don't expect a clear picture
I will
also.
try to provide the clear
Give me a
picture.
blurred picture, but why are you resisting again and
No,
again
my
and
lord,
again and
this
again?
is not the fact at all. First of all, when the
I'll record that you're not resisting and
No, my
direct him
lord.
to give connection to
My
order.
lord, kindly allow me to complete, my lord. When Partho Roy, the person affirmed this petition, came before this honorable court, claiming that respondent number 9 is raising the objection. What happened to that matter? When the WBSCDCL personnel went there, they found that the land is not mine. Somebody, third party's land is affected.
You are not giving any objection.
Today, the picture is totally different. Today,
Look
the
at this picture.
WBSCDCL does not know from where the land has to be acquired.
So why are you objecting?
Nobody is objecting right now. Now the matter is
I'll
pending.
record that you are not objecting. I'll direct them to demolish your objection.
I cannot object until and unless it
Raise
is
your voice.
Well, I'm sorry.
Don't raise your voice.
I cannot object until
Convince me otherwise.
I cannot
Please.
object until
Voice,
and until-
raising voice does
No,
not
no,
convince
no.
me at all.
I cannot object until and until it is known that which land will be acquired. Nobody knows which land will be acquired. On the last occasion when the matter was taken up,
We don't know what is being acquired. What are you objecting to?
that the authority is yet to prepare a sketch map, a proposed way that from this way the poles will be installed. That was the hearing held before the learned district magistrate.
You have
It-
not objected.
I will object in the event it is.
You
be
will
on
object
the
means
mind.
you have not raised any objection. What is pending before the district magistrate? If you have
Now
not
the situation
objected,
is absolutely different, my lord. Now the authority does not know where.
I want a straight answer from you, sir.
If
Have you objected, filed any objection, written objection or verbal objection
I
when
have
this
stated that
WBSCD? No. Well, let me complete my question first. Have you given any objection which is pending before district magistrate at present?
yes, because today.
What about this? What about re? I'll give objection if and then and but.
My lord,
You have given an objection on what ground? Your right was closed by the previous order.
No, my lord, but that has been referred to the district magistrate by the appellate court.
Let's set aside the entire proceeding before the district magistrate. They'll give connection within a week.
That my lord
Why
can.
not?
That my lord can, but
Give
today.
me one reason why you are objecting after that previous order of the court. One reason.
My lord, these lands are used for our personal purpose. If they erect pole and if they give high tension line, we will not able to use our land in a proper manner. And today, my lord, the picture is totally different. Today, nobody knows whose land will be acquired.
Nobody knows, you don't have a right to object then.
But
you also don't know. Nobody means you also are included
But
with
since
it.
we are the
You
major,
have no locus standi to
my lord,
object.
since we are the major landholders, we are apprehending that our land will be acquired.
On apprehension, objections cannot be filed, sir.
That is our case, my lord. That is.
I'll set aside that objection then. If you are apprehending something and objecting on basis of conjecture that this may happen, when it happens, we'll see. Yes, what answer do you have? It's pending before the magistrate because this is a fresh cause of action. 11 new pillars are being sought to post. It's actually running from pillar to post. So those are being installed now.
My lord, that your lordship.
So let that be decided by the magistrate.
That
Why
answer
not?
has already been decided. That's why I placed the later.
This same 11 posts.
Yes, my lord. 29 September later. Like kindly see, my lord. 29 September later, my lord, which I placed before your lordship. my lord.
Page. Give me the page.
Just a minute, my lord. So 124 is the starting, my lord.
Mhm.
13, my lord. Relevant will be, my lord,
Oh, that's
126.
very well, yes.
So, my lord, your lordship already they already took the cognizance of your lordship's
Who
order.
is Ajay Kumar Chaudhary?
He is the third party appellant, my lord, who preferred an appeal. Whose
The
appeal was
objection by
allowed.
Ajay Kumar Chaudhary was decided
Was
earlier.
allowed. So, my lord,
That
you-
was decided
that was
by the
decided.
district magistrate, not their objection. Now
All
they are objecting.
objections. Like, kindly see, my lord, WPA 20440 relates to connection of 68 distinct applicants, my lord. Today's, before your lordship also are these 68 applicants being represented by the society, my lord. Same people, my lord, 68 persons. So that has already been referred in 29 September 2022. Kindly see, my lord, as per 20440, if they had objection in terms of 20440. If not the earlier, because in earlier also, they're the same applicants, my lord, 68 applicants. They were before your lordship, in 20440, they were before the Honorable Appellate Court, my lord, in which, my lord, your lordship's order was not carried in appeal by the respondent number 9, my lord. As your lordship was correctly, has rightly observed, my lord, what is the locus standi of them to object, my lord, for twofold reason, my lord. Number one, they have not challenged your lordship's order, my lord, number one. Number two, my lord, they say that they were the owners. So once they were the owners and they sold the land, the question that would fall for your lordship's consideration, whether they can have a valid objection, my lord. My lord, if I sell my land to your lordship and your lordship apply for an electricity connection, will I be a bona fide objector in that case, my lord? Coupled with the fact that, my lord, I am coercing your lordship to take electricity from me illegally at 3 times the cost.
This was page 126 is the decision taken on the previous occasion.
It was, my lord, lordship directed to provide them temporary connection. And in the event they cannot provide, they have to give a reason, my lord.
This is that reason.
This is the reason, my lord. In which they said, my lord, the objections with respect to.
My lord, kindly come to page 134.
134 is the last order of the district magistrate.
8 polls. Your lordship kindly see. My lord has been saying is rest of the 11, that is not. It appears that the market value of the
my lord, that is the.
No, every time a new pole is being installed.
8 plus 11.
How many more poles are required to be installed?
Now, my lord, 11 polls.
11 are, this dispute is regarding those 11.
No.
8 have been installed already.
Yes, 8 has been complied. Yes, complied.
How
Now
many
we have
else
to
remain?
install another 11 poles to complete all proceedings.
That is the scope of this dispute.
That is the scope of it.
So how can that be re-raised?
No.
It has been already
No,
11 poles, the 12 pole.
That was not earlier referred. Only 8 polls was referred.
When was it referred to the magistrate?
That was, my lord, resolved. 8 polls are
When was the 11 pole dispute referred to the magistrate? The last one.
Well, that was in
More or less.
More or less February, and that was completed. All proceedings was completed. Hearing was taken place.
So I'll direct the magistrate to give his passing orders within a week, within a fortnight.
That
I'll
up
do
to your
that.
lordship.
Well,
my
that
lord.
is one
It is
part
not a case, my lord, that we are not
The
intent
difficulty is
to.
these are 11 more. 8 were decided. The rights have been decided. In the light of that, the magistrate will decide.
Yes.
That is all right, my lord. I'm not standing in that way, but my lord, kindly consider one aspect, my lord. Your lordship considered their objection. They raised objection before your lordship, but your lordship considered that since they are the owners, my lord, they sold their land to these vendors, my lord. They have an admission to that.
This objection now presently pending at present pending before the magistrate that has been raised by 9 alone.
Only line, my lord.
No, we have also referred. We have also referred.
No, you have referred on 9's objection only.
Yes, my lord. Kindly page 174.
I was present in the hearing. Ajay Kumar.
So he says the present picture is different. How is it different?
My lord, kindly come to
Absolutely
page,
different, my lord.
my lord, page 1.
How different?
Let them say what.
You tell me how different.
Well, the difference is today the 11 poles where they will install the pole. That sketch map is not prepared. On the last occasion when the matter was taken up by by the learned district magistrate, it was categorically submitted that they are yet to prepare the sketch map. In the event the sketch map is prepared, new persons may come. That is my only submission.
Order record. Learned counsel for the petitioner contends that despite several previous rounds of litigation, even after the issue of the entitlement of the petitioners to have electricity connection at the location in question having been settled, the WBSEDCL is yet to give such connection to all the applicants, all the 68 applicants, who are represented by their association, the present writ petitioner. Footstep next para. Learned counsel appearing for the respondent number 9, the present objector, submits that the picture has altered in the meantime. It is submitted that the previous dispute arose regarding installation of certain other poles, whereas 11 new poles are being sought to be installed on the property of the respondent number 9, comma, for which the respondent number 9 was constrained to raise objection. Full stop. Next para. Such stand is reiterated by the WBACTCL. Full stop. Learned Counsel for the licensee submits that the current dispute has already been referred to the district magistrate and has been heard before the said authority. Full stop. The said matter is on the verge of conclusion, comma, awaiting the order being passed by the magistrate. Full stop. Next para. Upon hearing learned counsel for the parties, comma, it is clear that the matter is undoubtedly checkered insofar as its history is concerned. Full stop. Next para. At the initial stage, comma, when 8 previous posts were installed by the WBACTCL for giving connection to the members of the petitioner, comma, who had applied for electricity connection, comma, the present respondent number 9, within bracket, also respondent number 9 therein, bracket closed, took an objection. Full stop. This court, comma, in the order dated March 4, 2022, passed in WPA 2229 of 2022, comma, had decided the said issue. Full stop. Next para. Scrutiny of the said order indicates that it had been contended by respondent number 9 that they are the that it is the owner of the property in question and has been supplying electricity to the occupiers and vendors thereat. Full stop. Next para. The electricity distribution licensee had taken a stand that the respondent number 9 is a bulk consumer and it is not within the domain of the WBACTCL to supervise as to which persons are given connection by the said bulk consumer. Full stop. At internal page 4 of the said order, comma, it was observed by this court that due to resistance created by the respondent number 9, comma, the electricity connection could not be given individually to the petitioner and the other vendors, within bracket, which covers the present 68 applicants as well, bracket closed. Full stop. It was also recorded that the respondent number 9 had taken a specific plea as regards the route over which the connection was to be given, comma, being owned by the said respondent. Full stop. It was observed by this court that if a person is in settled possession of a property, he or she is entitled under section 43 of the Electricity Act 2003 to get electricity connection at his / her occupied premises, comma, subject to compliance of all due formalities.
May I take back?
Full stop. But
may I come back to your lordship?
May you?
May I come back to my one matter?
Oh, yes, yes, absolutely. Keep somebody. You don't have any junior. You're saving all the fees.
No, junior is there.
Yes, yes, immediately. But then I'll pass certain observations against your client if you leave.
Not as you
take that risk. Yes, yes. Moreover, the petitioner and other vendors' occupation of the area had not been disputed by either the distribution licensee or the respondent number 9, comma, it was observed, comma, although respondent number 9 specifically disputed the legality of such possession. Full stop. In such circumstances, comma, it was held that merely due to an objection raised by the respondent number 9 as to the legality of the petitioner's possession, comma, the right conferred on the petitioner and other vendors who are evidently in settled occupation, comma, under section 43 of the 2003 Act, comma, could not be curtailed, cannot be curtailed. Full stop. Accordingly, the writ petition was disposed of by directing the WBACTCL to immediately make necessary installation and raise structures necessary for giving electricity connection individually to the petitioner therein and or other applicants, comma, if any, comma, subject to compliance of all due formalities in law by the petitioner and the other applicants. Full stop. Next para, certain other consequential directions were also passed in the said order. Full stop. After the said adjudication, comma, a dispute was raised by a third party, which was ultimately decided by the concerned district magistrate. Full stop. The district magistrate vide order dated November 22, 2022, comma, had ultimately observed that the licensee, that is the WBACDCL, shall pay an amount of rupees 17,934 to the private respondent for erecting 8 electricity poles and shall draw the electric cable through these poles to the petitioner. Full stop. Next para. Thereafter, the same was challenged, but ultimately no deviation was could be obtained by the objector therein to the direction of supply of electricity to the petitioner. Full stop. Next para. It is seen that at present, comma, the same respondent number 9 has raised objection when the WBACDCL is seeking to install 11 further posts on the land in question, comma, which according to the respondent number 9, comma, nobody is sure as to the ownership of. Full stop. Next para. Even supposing that the respondent number 9 is the owner of part or whole of the property over which the poles are being installed, comma, the works of licensee rules 2006 clearly specify that in case of dispute, comma, the same is required to be decided by the district magistrate. Full stop. Insofar as the present dispute is concerned, comma, the same pertains to the same subject matter which fell for consideration previously before the writ court and thereafter before the district magistrate. Full stop. The issue raised before the magistrate as well as the writ court was whether the WBACDCL was entitled to give electricity connection to the petitioners. Full stop. The corollary to such main issue was as to the amount of compensation, comma, if payable, comma, which was to be payable to the persons over whose land the installations were being made. Full stop. In particular, comma, the respondent number 9, comma, which was a party to the initial writ petition, comma, and is bound by the order passed therein, comma, cannot resile from such position and seek to reopen the final conclusion reached in the said writ petition by an order of court, comma, inasmuch as the right of the WBACDCL to give electricity connection to the petitioners is concerned, and or as to the right of the petitioners to get such electricity connection. Full stop. In particular, comma, the 68 present applicants had already applied at the relevant juncture as well, and their contention regarding their right to get electricity connection has been fully decided, conclusively decided on all earlier occasions. Full stop. After the writ court having turned down the objection of the respondent number 9 in the capacity of the owner of the land, comma, it does not lie in the mouth of the same respondent to raise similar objection when further electricity poles are being sought to be installed for the purpose of compliance with the order of the writ court and to give electricity connection to the other applicants who are also fruit vendors in the area. Full stop. Next para. Needless to say, comma, the applicants have to comply with other formalities, full stop, but comma, but insofar as the objection of the respondent number 9 is concerned, comma, the same has been rendered a non-issue after the previous adjudications and could not be reopened before the district magistrate again and again, comma, repeatedly. Full stop. Next para. Hence, comma, irrespective of the dispute raised by the respondent number 9 before the concerned district magistrate, comma, the same is a foregone conclusion in view of the order passed by the writ court on earlier occasions. Full stop. Hence, comma, the petitioner and its members, being the fruit vendors in the locality, comma, have a right to get an electricity connection individually for each of the applicants, irrespective of the objection raised by the respondent number 9. Full stop. However, comma, undoubtedly, the WBSETCL is also required to consider the question of compensation and quantum thereof, comma, if payable to the owners of the lands over which the 11 proposed electricity poles are being installed. Full stop. If a due application for compensation is made by the respondent number 9 or any other party, comma, the same shall be decided duly in accordance with law by the WBSETCL and compensation be disbursed to the entitled parties accordingly. Full stop. However, comma, in the event it is seen that the applicants are not satisfied with the compensation, comma, if any, comma, granted by the WBSETCL, comma, it will be open to such aggrieved persons to make necessary applications before the concerned district judge within the purview of the Works of Licensing Rules 2006 for an increment in the said compensation awarded. Full stop. Next para. However, comma, that there cannot be any further impediment in the electricity connection being given to the applicants over the 11 electricity poles which have been installed by the WBSETCL. Full stop. Hence, comma, WPA 12705 of 2023 is allowed, comma, thereby directing the WBSETCL to immediately take steps to give electricity connection to all the applicants who are members of the petitioner society, comma, whose applications are already pending, comma, irrespective of the objection raised by the respondent number 9 and or awaiting the outcome of the dispute raised before the district magistrate. Full stop. Such connection shall be given to the applicants in the pending applications as expeditiously as possible, comma, positively to all of them within 2 months from date. Full stop. Next para. However, comma, nothing in this order shall preclude the respondent number 9 and or any other aggrieved party stroke landowner to make appropriate applications for compensation. Full stop. If so filed, comma, the directions as given herein above shall take effect. Full stop. Next para. In the event the WBSETCL personnel face any objection from any quarter, comma, including the respondent number 9, in giving such connection to the petitioners, to the applicants, comma, it will be open to the respondent, to the WBSETCL personnel to approach the concerned police authorities for adequate police assistance. Full stop.
Respondent number 8.
Concerned police authority, comma, being respondent number 8, comma, the inspector in charge of the Sakrail police station, comma, Howrah Police Commissionerate, for adequate police assistance in that regard. Full stop. If so approached, comma, the inspector in charge, comma, Sakrail police station shall act on the written communication of the petitioner and or the WBSETCL and give such assistance to the WBSETCL personnel, comma, upon being satisfied on the basis of a server copy of this order without insisting upon prior production of a certified copy. Full stop. Such assistance shall be given with adequate forces, comma, if need be, by recruiting further forces from superior authorities, comma, at the cost of the petitioner society. Full stop. No rise to cost urgency. Urgent certified copies so that you can challenge us. But we'll argue, we'll try it. Thank you.
I'm so
Next
grateful,
matter.
my lord.
Look.
31.
Yes,
Lord,
Mr. Dottu, what is
I
the matter?
appear for the petitioner, my lord.
Mr. Gupta, you are for the
I appearing for the Steel Authority of India, my lord, the respondent number 1. May I file the affidavit in opposition? We are 2 weeks out of time, my lord.
My lord, lordship will recollect, my lord, I had mentioned this matter only citing the urgency. My lord, this is, my lord, challenging a contract which has been awarded to the respondent number 2 by the respondent number 1 pursuant to a tender process. Now the respondent number 2, my lord, claims to be, my lord, a micro small enterprise. The, my lord, bid document contains a provision that even if another, my lord, a my lord, micro small enterprise is, my lord, emerges as the, my lord, successful bidder, the, my lord, MSE has to be given a chance to match that bid. In the event the MSE matches that bid, then for 25% of the value, my lord, the contract has to be awarded to the MSE. Now here, my lord, I was the, my lord, I am Thermax, my lord.
Or 25% of the value means?
25% of the, my lord, contract, my lord, that is, my lord, what is there in the bid document. For that, my lord, the contract is to be awarded to the MSE. This is what the contract, the bid document.
What about the rest 75%?
My lord, rest should automatically, my contention is, come back to, my lord, the highest successful bidder. My lord, which is, I am the highest successful.
You are not the MSME.
I am not the MSE.
All right, very good.
Which is, my lord, basically the L1 bidder. I must, the expression used is L1.
L1, right.
Now, my lord, in this case, the contract has been awarded on 6th of May.
Please read out page 63, these right-hand column, this data. Those are very relevant.
63.
Page 63, right-hand column, those data.
My lord,
What are these?
I will not trouble your lordship with this. Lordship kindly ignores that. I will only, my lord, try. These are, my lord, because it is a, my lord, financial.
Can you read one sentence, one line of
It's a financial bid. It has to be in the encrypted form. That is the only reason.
Yes.
But, my lord, today I can
Anyway,
indicate
yes.
the figures.
So that is, show me the relevant clauses.
We shall come back with instructions on this.
Good one. Yes, Mr. Datta, show me the relevant.
Kindly comes to page 33, the bid document.
33, yes.
My lord, lordship kindly marks the, my lord, column with the heading item category. Lordship will find 16 categories of items are mentioned. Now kindly turns the page. The relevant clause is clause 2, page 34.
Purchase.
Purchase preference. I'll just place this for your lordship. Purchase preference to micro and small enterprises. Purchase preference will be given to MSEs as defined in Public Procurement Policy for Micro and Small Enterprises Order 2012, dated 23rd March 2012, issued by Ministry of Micro, Small and Medium Enterprises and its subsequent orders notifications issued by concerned ministry. If the bidder wants to avail the purchase preference, bidder must be the manufacturer of the offered product in case of bid for supply of goods. I will first show that he is not the manufacturer. I will also show that this policy will not apply because this is in the nature of a works contract.
It has been granted in its entirety to the MSE.
Yes, entirety. Traders are excluded from the purview of Public Procurement Policy for Micro and Small Enterprises. In respect of bid for services, bidder must be the service provider of the offered service. Relevant documentary evidence in this regard shall be uploaded along with the bid in respect of the offered price or service. Now, this is important, my lord. If L1 is not an MSE and MSE sellers have quoted price within L1 plus 15%, that is, my lord, selected by buyer of margin of purchase preference price band defined in the relevant policy, such seller shall be given opportunity to match L1 price and contract will be awarded for 25% of total quantity. Now, this is, my lord, I will show, my lord, the policy of 2012 and a recent, my lord, amendment in 2018. Initially, it was restricted to 20%. There was an amendment and it went up to 25%. That is why 25% figure
has it ever been held anywhere regarding the previous ones that the rest has to go to the L1?
I did not, my lord, find out that, my lord, any judgment on that.
Let's
now, my lord, kindly, after this, lordship kindly straight away comes to page 35 once. Because from the, my lord, opposition they have filed, my lord, threefold, my lord, objections have been taken. One is, it is a composite contract for supplies to be effected. So I would show, my lord, that it can be bifurcated. Second is, they say the Public Procurement Policy of 2012, which is now amended, that does not provide for...
What is their interpretation of this 25%?
My lord, their real contention from the affidavit, my lord, if I have understood it correctly, my lord, it is, my lord, it's a composite wholesome contract, cannot be bifurcated, and my lord,
25% has to be ignored.
According, they are
Mr. Gupta on this.
That is what I understand.
One thing, they have not yet used an affidavit in reply. So
my lord, my urgency,
they would use a reply. If they want to, my lord, we can have the hearing after that.
My lord, I will
Otherwise-
indicate the urgency, my lord. When I moved this petition before the vacation bench, my lord, the order, my lord, despite my lord giving opportunity to file
A
affidavit,
copy
said
of this opposition was given to you previously.
no. Once I mentioned on 5th of June, then my lord on 19th of June, the service of this affidavit was made on 26th of June. My lord, I had mentioned only citing the order passed by the my lord learned judge, my lord, in the vacation bench, which my lord provided me the liberty to approach the my lord regular bench for interim order. My lord, the difficulty is this: 150-day period is there for the purpose of completing the supply. My lord, the period ends on 3rd of October as per my lord the contract. My lord, hence the urgency. Today, I don't want Mr. Gupta's client or the private respondent to come and say that they have already manufactured or procured the goods for 100% value and therefore claim some kind of an equity before your lordship. That is the urgency.
Mr. Dattu, what is the, yes, let us continue.
Yes, my
with your
lord.
arguments.
My lord, kindly, my lord, first sees page 35. The delivery dates are indicated against each of the items, 150 days.
So you deal with their arguments first. I mean, you said they take threefold objection.
I just need to show, my lord, 3-4 pages and then I will straight away come to that objection. My lord, kindly comes to, my lord, page 47, my lord.
Page 47, yes.
47, my lord. Clause 3.
Hmm.
This is part of the bid document. Installation, commissioning, testing, configuration, training, if any, whichever is applicable as per scope of supply, is to be carried out by OEM, OEM certified resource or OEM authorized reseller, whichever is applicable. Now, my lord, one of my contentions would be that it is not simpliciter a contract for supply. It is in the nature of a works contract. So my lord has to consider whether the procurement policy would at all have any application or bearing in this case. That would be one issue. Now, my lord, comes to page 50. Roman 13, clause B. There are 4 numbers of waste heat recovery boilers at ISP Coke Oven CDCP plant. These boilers are Thermax make single drum water tube boilers with auxiliary equipment necessary to use hot gas from coke cooling chamber as fuel. Why I am showing this, my lord? Because my client is, my lord, Thermax, who manufactures these, my lord, products. But I have been excluded because of the, my lord, the process which has been undertaken. Now kindly turns the page, comes to page 51. My lord, details of the parts which are to be supplied, specific quantities, how many quantities of each part to be supplied mentioned in the bid document. Now, my lord, kindly comes to my lord, page 61 is, my lord, really the bid participation document, which lordship was looking at from page 63. Relevant portion I want to draw my lord's attention to is at 77. Again, my lord, at the my lord, bottom of the foot of the page, lordship will find the bid document also, my lord.
That it can be bifurcated.
It can be bifurcated.
That
Quantity, yes, my lord. 77. Now, kindly lordship comes to the result. My lord, the reverse auction, my lord, result starts at page 81. The relevant portion in a, my lord, tabular form is at page 86. Lordship may kindly come to page 86. At the top, lordship will find final result, my lord, 86.
Yes, 86.
List of sellers qualified financially. The first name is, my lord, that of the petitioner. The third name is that of respondent number 2, the MSE. My lord, sees the, my lord, figures quoted. I was the lowest bidder, L1 bidder.
Yes,
but because MSME participated, he was given a chance to match my price. He matched my price. My contention is, even if he matches my price, he will be awarded only 25%. My lord, immediately after this, my lord, my lord, communicated with the authority, which is respondent number 1. One such document kindly sees page 91. My lord, at the foot of that page, my lord, there would be an email of 4th April 2023 issued at 4:06 p.m. This is my email. We are yet to receive the firm purchase order against the above RFX. While inquiring, we come to know that you are going to award this contract to a MSME vendor.
That has now been awarded.
Which is now awarded. That lordship will find
yes.
at page 104. Kindly comes to 104.
When was it awarded, Mr. Datta?
This is the date, my lord. 104, my lord, at the top right hand corner, just above, my lord, beneath the expression contract number.
When did you file the writ petition?
My lord, this is 6th of May. I came to know of this on 17th of May. I moved the vacation bench. The order was passed on.
You moved the vacation, right?
Yes.
Very good.
We mentioned it before the regular bench on 19th of May and then got the liberty, my lord.
Right.
My lord, 104, this is the, my lord, contract. Then lordship kindly sees again, my lord, unit-wise price is mentioned against each of the items. This is the, my lord, contract awarded
We have
part two.
checked up, Mr. Dotto. This covers the entire thing, entire assignment.
The entire thing, 100% of it.
Very good. So this is the crux of the dispute.
This is the crux of the dispute, my lord.
Let us see
And
what
now
Mr.
comes to, my lord, page 1071.
7, yes.
My lord, we have come to know, my lord, page 101, when the, my lord, list of items described, the first 3 items, economizers coils,
Yes.
my lord, there is, my lord, a concept of finning which is required to these, my lord, coils. My lord, they are, respondent number 2 MSc is not capable also, my lord, for the purpose of this. And they would, my lord, outsource this part to somebody else, which I have information, for the purpose of procuring. Now, my lord, kindly one point is very important. My lord, we had in our writ petition in paragraph 9 made a specific, my lord, statement. Kindly comes to paragraph 9, page 8. Procurement policy.
Yes, page 8.
My lord, third line from that, my lord, paragraph. The respondent number 2 does not manufacture multiple parts of the CDCP boilers, such as finned coils, finned economizer coil assembly, and finned evaporator coil assembly.
So they're not manufacturers. They don't qualify.
No. In, my lord, SAIL, my lord, in their affidavit has not denied this fact, that whether they manufacture or whether they don't manufacture, I don't find.
Cannot even, yes.
Yes. Even if I
But
give
for
that
sale,
benefit.
Mr. Gupta, for sale, who is for the successful?
I had moved the writ petition upon service. I have mentioned the matters twice upon service.
He is selling on sales board.
Yes.
Yes, but yes.
My lord, if lordship wants the presence of the respondent number 2, I will definitely again serve and come back.
So you have served properly.
I have. Lordship kindly sees, my lord. I will give even the notices of mentioning I have
Yes,
served.
do they have notice of that? That is what
Yes, they have. They have. I have mailed every time, my lord, before mentioning, I ensured that they are served.
Let us see how sale defends. Yes. Here, let me hear Mr. Gupta. Yes, Mr. Gupta.
But firstly, my lord, there was a refusal to pass ad interim order. So there was no appeal preferred from
Well,
that.
allow the writ petition, that will take care of.
Yes, but after affidavits, it was directed. And firstly, you
Well, allow the writ petition, that will take care of the interim.
Yes.
So how do you overcome this 25%
Yes,
clause?
kindly
That is
comes
the
to, before taking your lordship to that page,
Hmm.
my lord will kindly come to page 33,
33 years.
where, my lord, the bid document starts.
Hmm.
My lord will kindly see the 7 or 8 columns from top, which says total quantity. It is 136.
Yes.
And my lord will also kindly mark the item category, the next column, the next row, which provides all the items required as per this NI.
The purchase agreement. These are
Yes,
are
purchase and installation.
what contract?
Purchase installation.
Installation.
Yes.
Very good. Then
My lord will kindly see in that item category.
installation in a particular plant.
Yes.
Very good. Let us continue. Yes.
My lord will kindly see
Hmm.
that in the item category, my lord, row, my lord, there is mention of the total number of items required and the number of items under each category required. That
You
is
say the work contract is 25%. Do you say that?
No, I'm not saying that.
Very
But
good.
I'm showing the composite nature of the bid.
Yes, right. Quantities.
Now kindly comes to the last column.
Hmm.
Last row, I'm sorry, my lord. Evaluation method.
Hmm.
Total value wise is evaluation. So there is no specific item wise rate quoted by the bidders. It's for the entire composite items required that the bidders are required to quote. Now, if my lord kindly turns over to page 34, my lord will see splitting. There's a head called splitting, and it says bid splitting not applied. So no item wise quotes can be made.
Hmm. That
Now,
is for an individual bidder.
Yes, but item wise quote. I am on my lord whether
Item wise quote cannot be.
quote cannot be split.
No, cannot.
It is entire.
Either it is to be for the entire thing or
For entire
Very
thing,
good.
for all the items required, there has to be a bid. My lord will kindly then come to my lord clause 2.
Mhm.
I'll trouble your lordship with only two clauses, clause 2 and 3. My lord, clause 2, my lord, really, my lord, the last sentence. If L1 is not an MSME and MSME sellers has or have quoted price within L1 plus 15% of margin of purchase preference or price band defined in the relevant policy, such seller shall be given opportunity to match L1 price and the contract will be awarded for 25% of the total quantity. This, my lord, in our in our humble submission, this 25% splitting was not practically possible for this contract. So, my lord, what had happened was, my lord, the entire contract was awarded to MSME on the basis of the MSME matching the L1 price.
But this is one of the goalposts.
This is one of the
Goalposts which you are
Yes.
changing after they participate.
But I'll show 2 or 3 other things. My lord. Kindly comes to, my lord, clause 3, reverse auction. My lord, this also says that, my lord, a reverse auction would be conducted amongst all the technically qualified bidders excepting the highest quoting bidder, and technically qualified highest quoting bidder will not be allowed to participate in the RA. However, H1 will also be allowed to participate in RA in following cases. We are concerned with the next page, item 4. If L1 is non-MSME and H1,
How does H1 come in here?
highest bidder can also participate.
That
possible.
is immaterial here.
So now,
None of them are the H1.
yes, and H1 price, eligible MSME and H1 price is coming within price band of
That is
15%.
immaterial. Yes.
So, my lord, what our contention was that, my lord, since the L1 bidder who was, since the L3 bidder who was the M1, who was MSME, had matched the price of the L1 bidder, that is why, my lord, we had awarded the entire contract. My lord, 101, my lord, will kindly see the price, and this is within that 15% range.
No. Regarding the other
25%.
criteria, Mr. Gupta, there is no dispute regarding the other things.
50, no, because they
They have matched L1
they had-
plus
there's a
15.
pleading in the writ petition that 15% is not there. To that, my lord, we have calculated and we have shown that in the affidavit that is within 15%. So what I need to address your
Two
lordship is
things
not
we need to
25%.
address: 25% and that they are not manufacturers of this, which is one of the eligibility criteria.
Well, may I answer the manufacturing thing first?
Hmm.
My lord, kindly comes to page 30 of the writ petition.
Mhm.
These are the annexures
Hmm.
in the writ petition. Kindly, my lord, comes to, my lord, the first entry, which is really serial number 3 at the top of
Yes.
the page. My lord, it shows it's a manufacturing unit and they are engaged in manufacture of, my lord, boilers and radiators. This is with regard to, my lord, the respond number 3. Respond number 2, I'm sorry.
But not.
That your lordship will find at page 29, top,
Acha.
my lord, respond number 2. Shanta,
No, but steam generators or economizer is not covered. Economizer is one of the terms I remember from your the bid document.
my lord, that is serial number 4.
4 contains includes economizer.
Yes,
but
that is
you
also
are on, we
manufacturing.
are on 3.
But that is also manufacturing. So everywhere they have been referred to as manufacturing units. Your lordship will see the next column. Everywhere they are manufacturing units.
So what is this? This is the particular bid of that.
No, this is, they have annexed to show that from the MSME documents, it would not depict.
No, this is whose bid?
No, this is not a bid. This is the certificate or the,
acha.
the download from the MSME website pertaining to respond number 2, which they try and establish that they are not manufacturing units. But in the affidavit in opposition as well, if my lord kindly turns over to, my lord, page 24. This is, my lord, the certificate which they had given us. My lord, will kindly come to page 24, annexure C. My lord, will find the major activities manufacturing.
In any event, the petitioner
And we
probably
are not
cannot
judge.
controvert this in the report.
And
They are not in a
neither
position
can
to
we.
know
My lord,
this.
we are also not judge of whether they are actually manufacturing or not. But we do not go and visit, my lord, their factories and ascertain whether they are in fact manufacturing. We rely on whatever MSME certificates they
It is
give.
for
It
eligibility.
is for the MSME authorities to decide and issue a certificate. Now, my lord, the issue of 25%. My lord, if my lord kindly takes a look at.
How can you give a go by to this 25% if you knew that it
Well,
could
that
not
is
be
exactly the only point which was troubling me while drafting the affidavit.
all of us are troubled by
Yes, kindly, my lord, comes to page 14, my lord.
Page 4 or
14, I'm sorry, 14 of the
Yes.
AO. Well, this is 27 January 2022 office memorandum
Page 14 of what?
of the affidavit in opposition. Well, I'm sorry. I'm really sorry.
No, no, it's solid. You are referring to that only. Page 14.
Well, this is an office memorandum of the micro, small and medium enterprises. It's the office of the development commissioner of the government of India. We'll kindly see what is written over there. It's revised FAQs. FAQs frequently asked questions or frequently answered questions.
That much I also know.
I'm sorry. Because of this.
Only that much, not the other technical terms. Yes.
In respect of public procurement policies for MSME order 2012 registry. This office has been receiving a number of inquiries or issues or questions or interpretations on the provisions of the public procurement policy for MSME order 2012 from the ministries or departments, CPSUs.
Show me the relevant answer, Mr. Gupta. I've seen the FAQ.
Only thing, the last sentence, this is in supersession of all previous FAQs.
All right.
Kindly comes to page 18. Question 16 first and question 21 the other one.
Right. Policy mandatory, yes.
And question 21. Can MSMEs quoting a price within the band L1 plus 15% be given complete supply to tender in case tender item cannot be split or divided? In case tender item cannot be split or divided, the MSME quoting a price within the band of L1 plus 15 may be awarded full or complete supply of total tendered value of MSME, considering the spirit of the policy of enhancing. This is on the basis of which we had to give
stated in your opposition anywhere that its splitting was not possible.
Yes, that is the entire case made out in the opposition. And relying upon the clauses of the bid document, which stated that it's not splittable, and the evaluation is for the entire.
Where do I find that?
Page 34 I had shown,
that one.
I'm sorry, I shall once again.
No, no, yes, you have shown. But
page 33, 3 columns, total quantity, item category, and evaluation method.
Mr. Gupta, how do you harmonize these two? Bid splitting not applied. Both are page 34.
And
Bid splitting not applied and 25% this percentage. How do you reconcile the two? I mean, tell me one situation when both can apply.
Cannot.
Then which one should go?
But because of the nature of the items and the evaluation process, which all the parties were governed by,
but
which is the
both
last
find place in your bid documents.
Both find place.
Then the meaning must be something else of the bid.
No, this, in my humble submission, only reconciliation possible would be.
Single bidder probably cannot split the items.
Or that can be one.
Or
and other is this might be a general term, and in case of a particular tender which cannot be split, all these have been indicated. But otherwise, this clause is there in this tender that I cannot shy away from.
Where?
Those are my suggestions.
Mr. Dotto, what relief can you claim now, even if you win the writ petition?
My lord, I'll come to that. Gives me 2 minutes, my lord.
Yes.
But only other thing, so far as whether it is practicable to bid to split or not and award the contract, for that I would otherwise rely on the judgments on the playing in the joints and whether it can be
formally cite those, just give the references.
My lord, kindly comes to my lord page 34 once. My lord, the question which Lordship just now put to Mr. Gupta, whether my lord these two clauses can be harmonized. My lord, I say that these two clauses are distinct and separate. Why I say this? Splitting, my lord, bid splitting not applied, according to my understanding, is that one bidder cannot submit a bid for some of the items and another bidder submitting for the rest. That is not permissible. This has got nothing to do with clause 2. And
it also
clause
prevents
2,
cartelization. Probably.
Yes, and clause 2, it is, my lord, a benefit which is being afforded, my lord, to a MSE.
To deal with the government policy?
My lord, kindly first is then, my lord, what was the government policy of 2012 and whether an FAQ will override the policy itself. Kindly says, my lord, 23rd March 2012.
If you have an extra copy, give it to Mr. If you don't have a copy, need not give it.
I will share it with him, my lord.
Give a copy, please. Yes.
My lord, kindly comes to clause 6, my lord. And this is, my lord, this policy was framed in terms of section 11 of the Act, Micro, my lord, Small and Medium Enterprises Act. My lord, clause 6, price quotation in tenders
In tender, participating micro and small enterprises quoting price within price band of L1 for plus 15% shall also be allowed to supply a portion of requirement by bringing down their price to L1 price in a situation where L1 price is from someone other than a micro and small enterprise. And such micro and small enterprise shall be allowed to supply up to 20% of total tendered value. My lord, there was, my lord, an amendment. Kindly says this now. They have a copy there. My lord, this is dated 9th of November 2018. Kindly, my lord, sees the second page, my lord. In exercise of powers conferred by section 11 so and so, central government hereby makes the following amendments to the public procurement policy. This order may be called so and so. My lord, it's really, my lord, paragraph
25%.
Though the public, yes, 25%, 20%, my lord, changed to 25%. And this was considered in the bid document consciously by sale. My lord, there is no, my lord, difficulty in interpreting, my lord, that upper part of that, my lord, bid document and, my lord, clause 2 can be, my lord, harmoniously, my lord, synchronized. And, my lord, the tender document, the bid document and the contract, my lord, from that lordship will find that separate unit-wise price, unit-wise, my lord, items have been described. So, my lord, for the exact 25% value, a contract can be awarded to the MSC. Rest, my lord, comes back to me. Because otherwise, my lord, my lord, who was, my lord, the L1 bidder, because of this condition, my lord, the MSC is matching my price. Otherwise, I would have got 100% contract. As far as, my lord, question of relief is concerned, because I was pressing for interim, kindly sees one prayer, my lord, in my writ petition. And this, in fact, my lord, I was, my lord, insisting, my lord, for this only. Kindly comes to page, my lord, 26. I am not giving up my point that this is, my lord, not even, my lord, a supply contract. From the contract agreement, I can demonstrate that. My lord, prayer K. In the alternative to prayer J, interim order in the nature of injunction be passed restraining respondent so-and-so from acting in furtherance of contract dated so-and-so once respondent number 2 achieves manufacture and supply of 25% of the total tendered quantity.
Not possible for the court.
My lord, in that case, it should go. My lord, I should not suffer. In the event, my lord,
relief lies in damages, whatever.
My lord, it should not, my lord, in a case like this. My lord, it is their document.
What else can you claim? Even if you have the work, your advantage is only in your monetary gain. So your relief lies in damages.
My lord, I am entitled to, my lord, the contract for the 75%.
Whether you are entitled to the relief of damages, I'll not relegate you to in your entirety. I mean, either I hold that you are entitled to, because this is bad, this contract awarding to the other person.
That is my first contention.
If that be held, then I'll give you liberty to approach the civil court for damages. I have to do.
My lord, if the contract is bad,
but if
if the contract cannot be split, then the entire contract.
The work is already done. The work is half
that is
done.
not there in the, my lord, sales affidavit. Not a single statement. Not a single statement. What is the, my lord, progress? My lord, if his argument is correct and lordship accepts his argument, then, my lord, it cannot be split. Then the entire contract should go. It should not go for, my lord, 75%. It should go entirely.
There is a scope of this K relief. How can the court implement this?
Then, my lord, lordship also considers, my lord, prayer J, my lord, because I initially, my lord, I was
go backwards up to.
No. Kindly, my lord, prayer J.
J, yes. Restraining response from doing what?
Taking any steps in lordship hears this out. Lordship, next week.
I've closed arguments right now. I've heard both of you.
Very well.
What remains?
Very well. Lordship.
Only one.
I'll pass my order within October 31st, the last date of finishing of the work.
Third.
Within that period, I'll definitely.
But only thing, question number 1, I had placed 16 and 21. Kindly see question number 1. This takes into account the notifications relied upon by my learned.
My lord, even that FAQ, my lord, says
that takes into account.
FAQ, whether the FAQ can override the policy.
This looking into the notification, interpreting the notification, giving the answer.
My lord, question number 21. It says in case of tender item cannot be split or divided.
Yes.
That is the, my lord, caveat.
Yes. Kindly see.
If it can be divided, why, my lord, this policy should not be adhered to? Why, my lord, MSC should be awarded the entire 100% contract? Why not the entire contract should go? And, my lord, on the question of compensation, my lord, last argument.
Yes, yes, make it.
Not the, my lord, principal argument. On the question of compensation, if lordship feels that as a writ court, lordship can definitely award compensation also. But I will still insist that lordship. I will still insist, lordship, that lordship holds in favor of the petitioner, and, my lord, set aside the, my lord, contract as a whole.
If you win, I'll appoint you as a court officer to decide what is 25% of the work. And to decide what
The
will be the
special re-
payment
the
for the
special referee.
special, yes.
My lord,
You will
can-
have to decide which is 25% of that contract. No, that has to be to their choice, to the buyer's choice. That choice has been given to you also.
My lord, I am entitled to, my lord, the prayers I have sought for in the writ petition, considering the, my lord, grounds I have, my lord, made out. Kindly considers that, my lord. Just because a contract would go does not mean that lordship would, my lord, shy away from, my lord, passing such an order.
I'm very shy on this. Absolutely shy.
We know lordship is not.
No, I am very shy on granting interim orders of this sort.
My lord, final order, lordship
25%
said
will
lordship is
stop
going
after 25%.
lordship said
Even
lordship
they
is going
cannot
to
decide
close
what
the
is
hearing,
25%.
my lord, final relief, not interim, final relief.
No, yes, I am closing hearing right now.
Yes. So, my lord, if it is final relief, lordship may consider this.
Very good. Heard learned counsel for the parties, full stop. The belated, the affidavit in opposition filed late is accepted upon condonation of the delay and be
Since I'm
kept on
not
record.
using a reply,
So I'll
lordship.
record that. Learned counsel for the petitioner submits that although it be deemed that the petitioner is not admitting any of the allegations made in the affidavit in opposition, comma, due to paucity of time and extreme urgency involved, comma, since the scope of the work itself will be exhausted by the end of October 2023, comma, the petitioner shall not use, does not intend to use a reply. Full stop. On on consent, comma, the writ petition was taken up for hearing on merits, and the hearing is concluded. Full stop. The matter is reserved for judgment.
Grateful, my lord.
Only one
So only
thing.
on this 25% basically.
Page 15, item number 1, your lordship will kindly take a note of.
Writ petition.
No, opposition.
FAQ,
FAQ item 1.
Oh, definitely.
Takes into account.
FAQ, I'll have to go through the FAQ, the other questions also to get the feel of it.
Grateful, my lord.
Thanks. Original side, I'm sorry, whoever is waiting.
So am I.